Regarding item number 28, hearing number, I have a prayer your lordship for adjournment.
28.
Yes, here the entire record LCR we have given for translation, your lordship, because
Top 22. Translation. You will appeal.
may take some more time because the records are very illegible to read.
Who has been given the task to translate? You.
We have person.
Okay.
Have been engaged in the month of April or March prior before this. Newly engaged.
How much time you take?
It was listed prior vacation, your lordship.
10-6.
Yes,
Yes.
but
When you will be able to translate all the necessary documents?
for 2 weeks, your lordship.
Ms. S. Das Gupta, Learned Counsel appearing for the appellants, has submitted that the process of translation is going on and the same is likely to be completed within a period of 2 weeks. First of Mr. R.J. Burwal and Additional Public Prosecutor for the respondent state is present. First of in view of the above submission made by Ms. Das Gupta, Learned Counsel for the appellants, let the case be listed on after 2 weeks. To enable Ms. Das Gupta to make submission as regards readiness of the translation process.
No,
I think you mentioned item number 24.
24. Yes.
Take it up, yes, to get it.
What is this? For orders. For orders, office note.
Yeah, it's a receipt.
Yes. Issued reminder. Records received. Then it will go for hearing. No, admit the appeal, already admitted. It will come up for hearing in usual course. Heard Mr. A. M. Ahmed, Learned Counsel for the petitioner, and Mr. R.J. Burwal, Learned Additional Public Prosecutor for the respondent state. Private respondent entered appearance or not?
Yes.
Ms. K. Bhattacharjee, Learned Counsel, has submitted that she has entered appearance on behalf of the respondent number 2 and 3. First of all, as the trial court records are received and the appeal has already been admitted on 26/5/2025 from our office to leave the case for hearing.
may I please, lordship? Lordship, with consent of the other side, lordship, I beg to mention item number 22, lordship.
22.
Yes, lordship, for orders, lordship. Matter may be
Yes.
kindly adjourned for 2 weeks, lordship.
Why it has come for IA? Okay, on the prayer of this,
As the lordship.
as they be Learned Counsel for the appellant, the case stands adjourned for 2 weeks with the consent of the with the consent of Mr. R.J. Burwal, Learned Additional Public Prosecutor for the respondent state.
Bless you.
Lordship, similar prayer regarding item number 23.
23.
So, for
Mr. K. Mira, see.
problem.
There is private respondent also. It is submitted that consent has also been taken from the Learned Counsel for the private respondents. Make the prayer.
I beg to which item 1, 4, 5.
1,
4 and 5.
1, 4, and 5.
Second. Next.
Huh?
Second school is the next one.
You are Mr.
Here, one more. The other extra.
A.R. Rahman.
Here,
On the prayer of Mr. A. Rahman, Learned Counsel for the petition. Come on. The case is adjourned for 1 week. Then 1, 4, and 5.
Lordship, I'm praying,
Repeat it, consent.
Lordship, I'm praying for an accommodation for the day in item number 36. Lordship, we fix any other day.
36. Yes. On the prayer of
C. Kalita.
C. Kalita Land Council for the appel. The case is possible for the repeat.
I am still with BA versus for some. Any day breaks to.
BA?
Yeah.
BA in what case?
So.
BA. BA is not before this court.
Also.
Okay, by paying for listing of a criminal appeal, my lord, it is already pending. Where we have raised the issue of juvenile eating. So there is some urgency. It will also
Next week, Friday. Next.
Lordship, item number 8, maybe adjourned.
Item number 8. On the prayer of Mr.
A.S. Chaudhary.
A.M. A. Chaudhary, Land Council for the petition. Case is passed over for the day. Mr. Burwa. 14. On the prayer of Mr. P.K. Kolita, Land Council for the petitioner. 28. 20 July. July.
29 July. Or 30.
29. Okay. Release the case. As paid for by Mr. B.K. Kolita, Land Council for the petitioner, release the case. On a date. In the first week of August. We still fix. Have you? Okay.
30.
In the week commencing from 4th of August. You have informed the CBI?
For today.
Yes.
No. Not informed.
Standing Council CBI. Yes. Is here 1 month. Is there any interim order?
Not
Is there any interim order?
for interim order, but for distance application. If stay order is there, that has to be extended.
That is what I have been asking.
Yes, yes. Stay order is there.
Entering the interim order, if any, shall continue till then.
May I please use? I pray for listing a criminal petition for orders.
Criminal petition for order next week. Okay, next week.
Similar prayer for listing, my lord, criminal appeal.
Not for hearing.
Not for hearing, let's press it. Yes. Item number 2.
Bit louder, bit louder.
Family court.
Family court,
Yes, ma'am.
125.
Yes, granting, my lord, the maintenance, my lord. The ground is there, the wife is a government employee, my lord. She is earning about 25,000 per month as per asset and liability, my lord, affidavit, my lord.
Hmm.
And the husband is a LDA, Lower Division Assistant. my lord.
Hmm. He is earning what?
He is earning about 37,000 something, and my
Hmm.
lord. And he has a,
So court has balanced it.
but my lord, he has a loan of 11,999, my lord, on record. And after that, my lord, he get only
Loan for what purpose?
for, my lord, he constructed an Assam type house for his own parents, my lord.
Hmm.
So his income
So
comes
that is
to,
an addition to the property only. It is not going outside.
but my lord,
It
present,
is coming back to him
yes, but my
in the
lord,
form of property.
yes, but my lord, presently 26,000 something he is drawing, my lord. And the wife is drawing 25,000 about, my lord, as 2024, my lord, record, my lord.
Well, you should notice at this stage. No interim order.
I can appear.
You appeared and will hear. Thereafter, if it is required to be Modified will modify.
Okay. Okay.
Heaven is not going to fall.
I will start.
Yes, state is not a party.
Okay.
Hard. Mr. You are entering on KVA.
Okay, but I just, what Uglat my visit.
Alert.
She is a government employee.
That is why alertness is there. Heard Mr. M.D. Khalil and counsel for the petition. The instant criminal revision petition is preferred against an order dated 16/6/2025 passed by the Learned Principal Just Family Court number 1, Kamrup Metro at Guwahati in FC within bracket CRL case number 188 of 2022. Whereby the Learned Family Court as directed the petitioner, comma, who was the opposite party there in the proceedings, comma, to pay an amount of rupees 6,000 per month as towards monthly maintenance to the respondent wife on a petition filed by the respondent wife under section 125 of the Code of Criminal Procedure 1973. So it is the contention on behalf of the petitioner that both the petitioner and the respondent are government employees, and there are only slight difference in the salaries of the two, and as such, comma, the direction to pay the above maintenance amount is not in conformity with law. So Mr. J. Ahmed Learned Counsel has appeared on behalf of the respondent on instruction and has submitted that he is going to file power on behalf of the respondent soon. So the matter would require a consideration issued notice returnable on soon. As Mr. Ahmed has appeared from our instruction on behalf of the respondent, sole respondent, issuance of formal notice is dispensed with. To the respondent, is dispensed with. Do you need a copy?
I will start.
Okay, Mr. Khalil and counsel for the petition shall furnish a copy of the revision petition along with an extract to Mr. Ahmed within 2 working days from today. The prayer for interim relief will be considered on the return. He has to pay.
She is getting 25,000, my lord.
Huh?
I have annex, my lord, page number, my lord, kindly peruse, my lord.
Both are, we'll see if he does not pay.
Page number 38.
Then we'll pass the order. Otherwise, impliedly it is there. Till the interim relief is considered.
Item number 3.
Yes,
Revision petition, my lord, against the government order dated 2/4/2025.
final order
Lordship.
on 25.
Lordship.
Yes, how much
In this case, my lord, 7,000 directed to.
is allowed? 4,000 to wife, second party,
Lordship.
and
6,000 to minors.
minor son. Yes, how you are?
I am, my lord, the respondent number 2, my lord, here. We ourselves withdraw the relationship from minors. And Island executed.
That is a matter of appreciation of evidence. Otherwise, 4,000, 3,000, what?
I will pay
Who are
the,
you?
I'm the husband. my
What is your status?
Now, my lord, earlier I was.
You are an employee, government employee,
No, my lord. I
businessman.
private temporary, my lord, private job, my lord. Earlier I was temporary, but now I have no jobless. my
Everybody says so.
lord. Shit.
After the
During
final
the
order,
lockdown.
everybody says.
After lockdown period, my lord, my job is. I will pay.
Where is your evidence?
Number 28.
Eloped, solemnized. 2010 marriage.
Lordship. It is 12, 2012.
So it cannot be denied that the first party is your wife.
2012.
Guardianship case.
I'm already paying the interim maintenance for per month, 7,000 million. Now, my lord, I'll pay 5,000 million. My old parents is there, my lord. I have to.
7,000. You cannot shy away from paying the
And my
maintenance
lord,
of
one thing, my
your
lord,
son. You have the moral obligation.
one thing, my lord, the respondent, my wife, my lord, he is not filed the assessment liability before the trial.
Will she do that, but we will only issue notice. 7,000 is nothing, 4 plus 3. How much old is your son?
He is born, my lord, in 2000.
Entity view is very less. Amount is very less. It should have been enhanced. Heard, Mr.
HM.
H.A. Ahmed, Client Counsel for the petition. Also, in this criminal revision petition from a final order dated 2/4/2025 passed by the Court of Learned Principal Just Family Court, Borpeta, in FC criminal case number 69 of 2022 has been assailed also by the order dated 2/4/2025, comma, the Learned Family Court has disposed of a petition prepared by the respondents. Why? Under section 125 CRPC, by directing the petitioner husband to pay monthly maintenance allowance at rupees 4,000 per month to the respondent wife and rupees 3,000 per month for their minor son. Close to issue notice returning. The petition shall take steps for service of notice upon the respondent by registered post today. By registered post daily as well as by usual process.
And this matter will, my lord, pass over for the time being.
Item number 7.
My please, your lordship. My lord, this petition is filed for quashing the entire proceeding arising out of the child marriage and POCSO case, my lord. Arising out of the child marriage and POCSO case, my lord. FIR is page, my lord, 18.
Page 18.
18. Respondent number 2, the alleged victim is the wife of the petitioner. Now they are peacefully, my lord, living their life, my lord, with their children. my lord.
Meter, a meter. I have noticed of the better one of the person in the Minadu. And then immediately you.
At the time of marriage, my lord, She was 17 years, 4 month, 21 days. Her date of birth is, my lord, is 19. 8/10/2004. And marriage.
You obtained this birth certificate after the FIR,
My lord,
huh?
my lord, S21, my lord. On
Page
21,
19, page 19,
my lord.
7/7/2023,
23.
huh? How you have obtained? With order of the magistrate,
No, my lord.
huh?
No, my lord.
Meghalaya,
Meghalaya. From Meghalaya. And my lord, page 20, my lord, one male child was born, my lord, out of their marriage, my lord. On, my lord, 5/1/2023. And she filed an, my lord, she shown an affidavit, my lord. That's nice. At page, my lord, 31.
Mr. Islam,
No.
come to page 23.
23.
Yes, Mr. Borua. Somehow it comes to my notice accidentally, almost always. Police report, page 23. Sarsit,
Charge document. And my lord,
date,
POXO case was registered. my lord.
date,
Next date,
date
my
of the Sarsit.
the date of the search sheet, my lord, on 36/2023.
Come to the table at paragraph 9. On birth certificate. Page 23.
Page 23.
Paragraph 9.
Details of
There is a
the,
table.
my lord,
There is a table.
my lord.
Property description.
The birth
Seal
cert-
number 1. You read. Seal number 1. You read.
My lord, one birth certificate in the name of the alleged victim, daughter of so and so, village Sidakandi, PS Dhupri, district West Garoville, Meghalaya, date of issue.
Date of issue.
7/7/2023.
See again the date of Sarsit.
Date of search sheet, my lord, 36/2023.
Which one is earlier?
7/7, my lord, search sheet is earlier, my lord.
Then,
Search sheet earlier, but my lord,
then
my lord, at the time of investigation, my lord,
have you understood my query?
my lord,
Have you understood?
search sheet was, my lord, earlier.
Sarsit is earlier.
My lord,
Then how in a Sarsit,
my lord.
a document of future date can be included?
No, my lord, no. Perhaps, my lord, search sheet was, my lord, prepared letter.
How
then-
can it be, sir?
My lord, record may be called from the. My lord, I need to, my lord, obtain instruction, my lord.
You address on the issue. Everything has become doubtful now.
My lord,
IO's conduct is also doubtful now.
my lord. Because, my lord, search sheet, my lord.
IO's conduct is also doubtful.
Prepared.
FIR was lodged. Thereafter, you obtain the birth certificate. To obtain a birth certificate, you need a magistrate's order. You got it. But at the time of searching, the cart is before the horse. Is it not? Yes, mister, you have to explain.
It may be, my lord.
This is your IO.
And then you present some, my lord, maybe, my lord, this birth certificate was submitted, my lord.
Yeah, how can be? How can it be?
Definitely.
My lord, search sheet. Perhaps search sheet earlier and it was
There was-
pending.
Cannot
there
be.
is- There was no speak to my client.
Huh?
There was no speak to.
Then your IO's conduct is doubtful now. He has gone out of the way. That is a different issue. Whether we'll show some leniency, that is a different issue. But how can this an officer, government officer can make it happen? Both of you should give proper explanation. It is repeated. Caesar, this one was. Come to page 24. Another table. One birth certificate. Date of issue. Hmm? It is not a page number 24, 26. Document cited, relied upon.
Same thing was reiterated. Caesar list.
Search it. We'll call for a scan copy.
My lord.
But what is, have you appeared?
Technically, my lord, the case of performance.
Huh?
It also has to do.
Hmm. No,
So
she's a
warrant
party,
is-
I think. She's a party.
See the part,
Well, she's the party. now. And she.
She is about, according to you, on the basis of that birth certificate, she was 17 years, 4 months.
Yes, your lordship. Well, page 31 is the my lord affidavit shown by her, my lord. And 30
You are living happily.
Yes, your lordship. With a male child.
Yes, Mr. Borua.
scan to be controlled. Scan to be.
And what about the trial? Did you appear?
My lord, the non-bailable warrant was issued.
Non-bailable warrant.
Not a clear. But
Why?
this
In
counsel.
the search sheet, you were shown as absconder or what?
Absconder, your lordship. Page, my lord, page 23.
23.
My lord, para 10, last Roman 12, 22, my lord. Status of the accused absconder.
This is my lord, that order DS ended on page number 30. It is the order dated 9/6/2025. He has only annexed one of the order wherein the DPW has been. I have to get my lord earlier order here.
You have the earlier orders.
No, my lord.
Search sheet
he
was
has-
of 2023, right? Now, what relief you are seeking now?
My lord, enter proceeding, my lord, question for enter proceeding, my lord.
Okay,
Well,
but
it
so
in a
far as
similar-
NBWA is concerned,
My lord, in a
if
similar-
it has, the court has properly followed the procedure.
Oh.
If you are not challenging the legality, then I cannot state as a NBWA.
My lord, in a similar situation, my lord, and coordinate bench, my lord, page 34, my lord. My lord, I have annexed the judgment, my lord, for quashing the similar proceeding, my lord, already in the bill.
Bhajanlal says what? Bhajanlal says what? Whether a privacy case is not made out, then quashing. Your case is completely different.
My lord,
Your
here
case
the-
is privacy case is made out.
my lord, here
Now
the-
cases of quashing on the basis of subsequent living together and having a child born. That is the issue here. See 1, 2, 3, 4, 5, 6, 7. Where it comes? Bhajanlal, come to page 36. Where it comes? 1, 2, 3, 4, 5, 6, 7.
That basically the chances of my lord conviction is bleak, my lord, only that,
That is also not issue, chances of. Only that, only for securing the ends of justice, nothing else. Because in none of the cases, in none of the situation, your case falls. It is a non-compoundable offense, but court to secure the ends of justice can quash a proceeding. It would not come under Bhajan Lal.
Also, it's correct.
But all things are doubtful.
Some of the will verify from the skin.
Let the lady come.
Correct, yeah.
On the first day itself, if a lady comes and says, then we'll see. Yes. Heard, Mr. You take the steps.
My lord.
It will be as part of practice direction or what? Steps for service of notice. As part of practice direction
Yes. Both for the
or through the registry or public prosecutor.
go through the, to our office.
Heard, Mr. M. Islam. Learned. Counsel for the petition. Petitioners, who are they?
My lord, who is the father of the accused number, my lord, the husband of the petition number one?
Against,
Fifteen, my
why
lord.
not? Because he performed the side marriage planning. Against the
Who is the father of the, my lord, the husband of the?
So it's not against the.
POCSO is not against the father. And Mr. R.J. Burua, learned additional public prosecutor for the respondent number 1, State of Assam. Dostum. The a first information report was lost. Interrelated to the effect that the petitioner made it a minor. And the CDFR was registered as Supsar Police Station, case number 27, stroke 2023. On 2/2/2023. After investigation, eight class. By charge number 95 stroke 2023 was submitted on 30/6/2023, finding a privacy case against the petitioner under sections 9/10 of what? 9/10 of what?
9/10,
of Prevention of Child Marriage Act.
my lord.
Read it. Section 6/17 of the POCSO Act 2000. On submission of the first process was issued to the petitioner, to the two seated accused persons, that is the petitioner's hearing. Question. The proceedings of the trial, special B case number 245 of 2024 before the special judge, and a special the South Salman Markasa, has resulted into issuance of non-bailable warrants, warrant of arrest against both of them. Mr. Islam Learned Counsel for the petition has submitted that the petition number 1, then petition number 1 can enter into accordingly. When the petition number one had entered into the marriage in 2022.
My lord, married on, my lord, the 10/2/2022.
And at that time, comma, his wife was about, was 17 years, 4 months, 2 days, as her date of birth was 8/10/2002. Postal. Out of the conjugal relationship, comma, a child was born on
Child was born on, my lord, 5/1/2023.
5/1/23.
5/1/2023. Now she is, my
Support
lord,
such contention, comma, the petitioners have relied on on their birth certificates issued on 7/7/2023 and 16/10/2023 respectively. As the petition number one and the respondent number two projecting that the petition number one and the respondent number two are living together since then. The petitioners have approached this court seeking passing of the charge sheet dated 36/2023. Close to issue notice returning on for detailed review. As Mr. Purva has appeared accepted notice on behalf of respondent number one. For my notice, the respondent number one is dismissed. You don't need a copy. You need a copy. The petitioners shall take steps for service of notice on the respondent number two. By, in terms of the practice direction. The learned additional public prosecutor is to obtain a report as regards service of notice upon the respondent number two from the officer in charge. Which police station? Suksar
Suksar.
police station. To place the scene on the returnable table. He had his submission order liquidable. Mr. Islam has also relied upon an affidavit sworn by the respondent number two, within bracket annexer 6 to buttress his submissions. You bring your wife.
My. Will you apply for it?
Without fail, you appear through counsel, then we'll decide.
Item 9.
Thank you, sir. The 528 of which years?
What you were challenging?
Register case number 28, Lordship. This is the interim order, Lordship.
28.
28, Lordship. 28, Lordship, and on 16 November
28.
2024, yes, Lordship.
Yes, Secretary.
First, Lordship, my Jima petition was rejected, Lordship, on 16 November, Lordship. And in the meantime, 27/3/2025, Lordship, they passed an order to auction through the public auction, Lordship. This is my
Now, what is the stage?
stage, Lordship. I'm praying for the just not to. Not to say-
27.
not to say
Yes,
the-
Mr. Borua, Ereka Nath.
Yes, Lord, suspected to be permissive paradors.
You are, let us see the FIR first.
Page 16, Lordship.
Page 16.
Yes, Lord.
Line
405
mission,
percent.
yes, of all the transfer, some. Fayaz. Wagoner. What is the vehicle?
So I'm not for a bag,
Oh,
so the bag are
for-
already granted. Lords. I'm for Arakan, Lords.
Dilwar Mustafa. Come to page 22. You submitted two custody petitions.
Yes, Lordship. Page 22, 16, 11, 24. On that day, I rejected my Jima petition, Lordship. Triple 2024. Jima petition number.
Earlier petition was rejected.
Regarding vehicle allowed, sir.
Vehicle was allowed.
Erekana detected because my lord, the examination report was pending.
Yes. Come to page 28, Mr. Burua. Earlier, he filed a petition for Jima, for Erekanath also. That was rejected on the ground of non-availability of chemical examination report. Now, the petitioner perhaps filed another petition. Right? That was disposed of earlier. Now come to page 28. Last para. IO mentioned. It is also mentioned that even in the later stage after the auction, if any true claimant appears. Now he is already a claimant.
Yes. For that purpose, my lord, I showed two things.
Huh?
I showed two things. Is that claimant, my lord, he is claiming he is the owner of the Erekana. For that, my lord, may kindly see the FIR. What is the date of the FIR?
No, first he filed a custody petition for both Erekanath and vehicle. The Erekanath petition was dismissed due to non-availability of chemical examination report, not on the merits of the claim made by the petition, right? Then vehicle was granted. Thereafter, IO made a prayer that this Bitul Rekanat are to be sold auction through because there was no claimant and court allowed it. Then why not he be given a liberty to prefer an application before the trial court?
The question I kindly say this, my lord, keep in order.
Let us see the impugn order. IO said, tried his level best to find the true claimant of the seized goods. But he, claiming custody, already filed an petition earlier.
They have filed, my lord, and it was rejected, my lord.
Right.
After that, my lord, he could have approached the IO, my lord. He could have approached the.
That is
IO.
what I am saying, that why not he be granted a liberty to file a
But it is required, man, because earlier, my lord, when it was rejected, my lord, was rejected specifically on the ground that, my lord, the examination report was more basic, my lord.
right.
Whether it is a human consumable or not.
Subsequently received or not chemical exam.
Particularly, it's a, my lord. That is
It's
why, my
private
lord,
annex order. Lordship.
that is why, my lordship may kindly come to page number 29.
After getting the lordship, that chemical report lordship, I have approached lordship.
Page number 29, second paragraph.
Oh, where is that?
Page number 29, second paragraph.
Or is it after it also? It is also appended in the petition, that the appended in the petition, what appended? That the seized item are not suitable for human consumption. They are hard so and so. Next para. Read. Is there anything observation that it is not fit for?
Case record as well as the document such as physical verification report of Erikanath, very district agriculture officer concerned. It shows report regarding the weight of the case which that is Supari Bitalnath report submitted by the public as laboratory photocopy of the CRT submitting message regarding Supari businessmen to claim the safe Supari. Also paper publication in Bengali and English to claim the safe Supari by the lawsuit.
Why did not you make claim when paper publication was made?
See, I have approached lordship. Yes.
Where?
Concerned PS lordship.
Concerned PS where?
Yes, lordship. After getting the chemical reports, lordship,
Huh?
they have denied to hand over. After getting the lordship, chemical reports. lordship.
There is nothing to substantiate such submission that you approach the court. Because your petition was never dismissed on merits of your claim.
Yes, lordship.
Then how you can approach this court
Lordship.
without first approaching the
Yes,
magistrate
lordship,
court?
I have, not to lordship, sold to the auction lordship. This is the public
So
auction.
you prevent that by preparing an application.
Yes, lordship. I,
Still, my lord, the IOs, from the court is that, my lord, after the auction, the amount which was, my lord, gathered after the auction.
Yes, that is
Then,
one.
my lord, give it to the, my lord,
We are not sure from here that this is not fit for human consumption. From your order, not
My
mentioned.
lord,
IO's prayer is there first.
After that, page number 29, my lord. Page number 29, last
Stated.
paragraph. my lord. Considering the above discussion, documents available submission, this court is satisfied that IOS tried to leverage this to find the true payment of the sale goods and the goods are perishable in nature and also decaying in the premise of the police station and same is not suitable for human consumption.
Here position or BNSS. Civil. Sales here is over. When the first petition was disposed of,
1611.
1611,
then this second order,
2020.
now madam, come to see. I don't know what is BNSS. Come to Mr. Borua. Come to section 458 of CRPC or 504 BNSS. Madam, do you have the CRPC? Do you have the CRPC? Oh, you read together. Either 454 CRPC or 504 BNSS.
504. 504.
Okay, read.
No person within such period or establish his claim of such property and if the person in whose possession such property was found unable to show it was legally acquired by him. The magistrate may by order direct and such property shall be at the disposal of the state government and may be sold by the government and the proceeds of such sale shall be dealt with such manner as the state government may by rules and regulations.
Now, read the next line. Subsection 2.
An appeal shall lie against its order of the court, which appeal ordinarily lie from conviction by magistrate.
What does it mean? Yes, Mr. Burwa. What does it mean? It is an appealable order. When there is a specific provision of appeal is available in the code, how can a revision petition is to be helmet anyway? It is,
Only Lordship-
Miss, 482 or what, 528 is not panacea of all ills. When there is a provision for appeal, and order is an appealable order, right? And the appealable forum is different. Why should I entertain this petition? First query.
Lordship, my prayer only Lordship not to sell the this.
That is an appealable order.
Yes, Lordship.
You approach the district judge, get an order of stay. Why should we entertain this petition? When a person without exhausting the appellate remedy approaches the High Court under the guise of 528 or 482 CRPC, why should we entertain?
CS come almost after years of 2 months. The order of.
Appellate court has the power to, since it is a court, it has the power to entertain an application under section 5 of the limitation act. But why we should? when there is an appellate remedy. Everybody is entertaining this kind of petition. You also consent to it. Is it not?
Lordship, I have annexed on the Jasmine affects for Jasmine also, Lordship.
Ambalal, that is a different issue.
So there's mentioned some speedy decays or there's some.
Sundar Bhai Ambalal Desai,
Yes, Lordship.
that is also not applicable everywhere. First, you have to, there is an appellate remedy, miss. Think it over, we'll post it tomorrow. We'll give you liberty to approach. This is not the way to entertain every petition when there is an appellate remedy. Heard Miss R. Rangmai, Learned Counsel for the petitioner, and Mr. R. J. Borwal, and additional public prosecutor for Grasman State. Those of the Learned Counsel for the parties shall address the court. About the maintainability of the petition under section 528 BNSS stroke 482 CRPC, when a specific remedy of appeal is available to the petitioner under section 458 within bracket 2 CRPC stroke 5042 BNSS. Please the case, therefore.
Number 10. My pleasure, also. So, this is criminal petition under section 528 BNSS, my lord. We are challenging here, my lord, impugned judgment passed by the Principal Judge Family Court, my lord, under section 125 CRPC. In this case, my lord,
5,000.
my lord, 5,000.
5,000.
We are challenging here on the strength of, my lord, honorable apex court order, my lord, that was stated in my paragraph 8, my lord. Kindly go through the paragraph 8. Page 7, my lord. May I read, my lord?
What is your status? Are you a government employee?
No, no, no.
Businessman?
No, my lord, daily wages are not.
Daily wage earner?
In this case, my lord, I
Did
would
you
like-
file? Did you file any statement on your own?
during trial, my lord.
During trial?
No, my lord, during trial, that is my
Did
case,
you
my lord.
raise that issue?
No,
Did
no.
you raise that issue?
My lord, asset and liability, my lord. No, my lord, that is my case, my lord.
When was the Rajneesh?
My lord,
When was the Rajneesh judgment?
it was decided, my lord, I have that judgment, I'd like to.
No,
place.
tell me the date of judgment.
Is a date of judgment, my lord. November 4, 2020, my lord.
November?
4, 2020, my lord.
Rajneesh is 2020.
Yes,
Let's
ma'am.
see. Let us.
My lord, on the strength of this judgment, coordinate base of this honorable court, my lord,
We'll
Pass the-
we'll go to that.
my lord, this.
Don't jump to the coordinate bench judgment
No, my lord,
immediately.
both are.
Let us see the judgment of Rajneesh.
My lord. The relevant part is paragraph 65.
Have you denied that you are not an employee in a cement factory?
No, my lord.
Have you denied?
No, no, I had no.
Huh? Have you denied in your pleadings?
Yes, yes, I have denied, my lord. That is in our WS, my lord. WS annexed with my petition, my lord. Paragraph 17 WS, my lord. And page 17.
Are you suffering from any disability? Are you suffering from any disability?
My lord, yes, my lord, I am suffering some disabilities in that regard. My medical documents available with me, but that medical documents I have not annexed with my petition.
Ah.
Present petition.
Well, you should notice that distance. I've said
That is,
5,000 is not an amount which is required to be interfered with at the interim stage.
on the extent
Maybe
of,
finally.
on the extent of Apex Court judgment, my lord, coordinate bench of this honorable court, my lord, on the motion stage itself, dispose of the case, but by direct set aside the impugned judgment, my lord. My case is similar on the nature. my lord.
Motion said we are not setting aside.
And my lord,
We'll distinguish that.
my lord,
We'll distinguish that. Give me your judgment.
coordinate judgment I have placed. my lord.
Without hearing the opposite party.
My lord. Motion. Because there is a violation of a law is there.
We'll examine that issue.
In this judgment, my lord, relevant paragraph of the Rajnath's case, my lord, quoted.
1 minute, this is the principal just. of a time. The case is disposed of without hearing the other parties, it will be vulnerable. It will be vulnerable.
On the extent of violation of law. my lord.
Cannot be. We are not examining anything. The trial court reports.
In the judgment.
Is served by Dusty. Let her appear. And we'll decide. Heard.
Till,
Mr.
my lord, on my interim prayer, my lord. The petitioner at this moment taken custody due to non-payment of the, my lord, area maintenance, my lord. He may be allowed from the jail, my lord, because there is a violation of
Oh.
law is there. And page, my lord, 55, by this order, he was taken custody.
It was an intra-party order or ex-party order? Contested case?
Yes, my lord.
Contested case decided in 2022?
22, my lord. Subsequently, the respondent filed another petition for realization of the entire amount, my lord, default amount.
Now area is going beyond 3 lakhs.
3 lakhs, my lord.
Only issue notice, heard Mr.
AK Azad, my lord.
A.K. Azad, Land Council for application. And Mr. R.J. Burwal, the resolution.
Formal party.
You are a party? You are a party?
Party.
That's one number one constitution.
By the Rajnath judgment, my lord, asset liability says mandatory, my lord.
Limitation. Limitation. Limitation.
Sorry, my lord, in this petition, I have placed another ground. Now the victim girl subsequently married with another boy, my lord. And she is continuing her second conjugal life with her second husband. She is not in trouble now, my lord. In that regard, I have annexed some documents, my lord.
So this court is raising one ground. This is a final order.
My lord.
The order is a revisional order.
No, my lord, arising out of the same judgment, subsequent proceeding is there.
The order,
Subsequent proceeding is there.
please wait.
My lord. So,
What is the original process? And what is supplemental or incidental proceeding? Which is to be treated as the original proceeding, Mr. Counsel? Tell me now. You were speaking about Rajneesh and Rajneesh. Tell me, what is the original order? 10/6/2022. Judgment,
yes, ma'am.
right?
Correct.
Then tell me, when, within what period of limitation this order,
60 days limitation period is there for approaching my lord revision.
from where you are saying? Which provision?
Okay. I exactly, my lord, I have not remembered limitation. Provision from the limitation, my lord,
90
exactly,
days,
my lord. 90
gone,
90, but yeah, we are.
gone. You cannot take the, under a guise of 528.
My lord.
It is an order which is revisable. Now you have come before the court under the guise of 528. When supplemental proceeding was initiated, had resulted into an area of 3 lakh,
My lord.
more than 3 lakh. Non-bailable warrant of arrest was issued. You were taken into custody.
My lord.
Now you have remembered Rajneesh. When your petition is to be dismissed on the ground of limitation.
My lord, under section 4832, my lord.
No, cannot be. Everywhere.
528,
Not for ends of justice everywhere.
from the same facts and circumstances, my lord, I have placed the coordinate bench judgment, my lord.
Yeah.
Entertain, my lord. After-
Okay, we'll also
After
decide
extra-
this issue at the motion stage.
At this stage, notice will
Yeah.
be issued, my lord. Notice will be
Give your coordinate bench.
The, in this case, my lord, parent case was also after expiry of limitation period, my lord, filed before the.
Yes.
But coordinate bench judgment I have placed, my lord.
And that is in ignorance of the
That was.
Limitation Act.
That was also filed after law. expiry of
Statutory
limitation
provision
period.
is ignored, so par inquiry.
At this stage, I am paying for notice.
Issue of limitation is kept open because of the entry in the Limitation Act. We'll decide on the returnable date.
My lord.
Let the lady appear.
My lord.
You are an employee of a cement factory in Bhutan,
My lord.
earning 30,000. Able-bodied man. Did not pay the maintenance amount despite the judgment in 2022. 5,000. Now you have remembered Rajneesh. When your petition is to be dismissed in limine. Hard. Mr.
AK Azad, my lord.
A.K. Azhar Learning Council for the petition. Petitioner in this criminal petition. File under section 528. BNSS has a sale. A judgment. $528 or what?
520.
When it's a family court, Mr. Borua, why you are not pointing out family court? Why don't you, as an officer of the court, why don't you point out? Section 19(1), non-obstante clause. Family Courts Act. There is an appealable order. An appeal lies. Neither criminal petition nor criminal revision petition. Judgment dated 10/6/2022. Provide a learned family court. In a petition preferred under section 125 CRS. Comma. Granted, has granted. Had granted a maintenance allowance of rupees 5,000 per month. 2 terms. First party therein, that is the respondent number 2 hearing. Also. Issue notice, returnable books. Also, it is noticed that Section 19(1) of the Family Courts Act 1984 is written non-obstante clause. And it has provided that notwithstanding anything contained, it has entirely provided that notwithstanding anything contained in the Code of Criminal Procedure 1973 or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order, of a family court to the High Court, both on facts and on law. Full stop. Every appeal under section 19(1) of the Family Courts Act shall be preferred within a period of 30 days from the date of the judgment or order of a family court. Full stop. Para. It is further noticed that even it is assumed that the order judgment dated 10/4/2022 is revised, then as per NT 155-115, CFS. An order, a petition is to be filed to the High Court within 60 days from the date of the judgment. Close for para, learned counsel for the petition has to explain on the point of, or has to make submission on the point of maintainability of the petition on the returnable. The petition issue notice returnable, so and so. The petition shall take steps for service notice upon the response number 2 by registered consultant 80 as well as by usual process will be retrieved in this point.
Masum.
Timing method, Article 6.
May I please, Lordship, Lordship, I have a little prayer, Lordship, not for fixed for day after tomorrow, also, on 25th, Lordship.
25th, no day after tomorrow. Will not keep it pending.
Lordship, 24, Lordship, I have some personal problem.
Tomorrow then,
Yes, Lordship.
Monday, Friday, Friday. You want it on Friday? You want it on Friday?
Yes, sir,
25th.
25th Friday.
Okay.
Timing method, item number 6.
May I please?
Yes,
My lord, this petition is under five, 28, my lord.
528.
Yes, yes, my
Okay.
lord. Wherein, my lord, we have challenged the order of the learned, court below, my lord, page 25.
Yes,
By-
25.
by, my lord. Here, my lord, after, on a complaint. by-
Complaint case.
Yes, on a complaint by the labor inspector, my lord, under the Plantation Act 1951, my lord, a cognizance was taken and summons was issued to the director and the manager.
Hmm.
So, my lord, the first ground is that, my lord, the cognizance was taken in violation of, my lord, section 39 of the Plantation Act. Section 39, my lord.
39.
39, my lord.
Who filed the complaint?
My lord, the labor inspector.
You want to say that there is no sanction?
No sanction, no
Okay.
sanction. In the complaint.
In the complaint is not
it has
mentioned.
Been stated.
Okay.
This is, my lord, the first ground.
Ah,
The second ground is, my lord, the director cannot be, my lord, the summons cannot be issued to him because he was directly not involved with the management of the affairs of the company.
okay, we'll decide that after appearance, but
My
so
lord.
far as prosecution sanction is concerned, we'll stay.
My lord.
Heard Mr. H. Gupta, land counsel for the petition. In this petition prepared under section 528, comma, P and SS 2020. The petitioner has internally assailed the proceedings of a complaint case, comma, CR case number 255, stroke 2025, comma, presently pending before the Court of Learned Chief Judicial Magistrate, Sonitpur at Tejpur, Posto. Para. The complaint case was filed by the labor inspector, cum inspector, O/O, the assistant labor commissioner, comma, John Roman 3, Tejpur, Sonitpur, as the complainant. Alleging violations of the provisions of various provisions of the Plantation Labor Act 1951 and various provisions of the state rules framed thereunder. Full stop. In a complaint, comma, the petitioner has been arrayed as the opposite party number 1. In a, complaint has arrayed two opposite parties and the petitioner herein has been arrayed as the opposite party number 1. So, para. It is contended on behalf of the petitioner that the petitioner is the managing director of Messrs. Mana Bari Tea Company Limited. And the opposite party number 2 in the complaint case, CR case number 255/2025, is the manager of Topia, TOPIA, Tea Estate, Sonitpur. So it is stated that Topia Tea Estates is run under the aegis of AEGIS. Messrs. Manabari Tea Company Limited. Full stop. Mr. Gupta, learned counsel for the petitioner, has raised a number of grounds. Full stop. One of the grounds of challenge is that as per section 39 of the Plantation Labor Act 1951, no court shall take cognizance of any offense under the act except on a complaint made by, or with the previous sanction in writing of, the chief inspector. Full stop. And the complaint petition in CR case number 255 of 2025 has been filed by the complainant without such previous sanction. Full stop. But it is further submitted that the learned court of subjudicial magistrate Sunitpur, Tejpur, have taken cognizance on the complaint by the order dated 4/3/2025 without such sanction. Post of a matter of required consideration, issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the opposite party respondents by registered post AD within 3 working days from today. In view of the specific provision contained in section 39 of the Plantation Labor Act 1951, requiring sanction before cognizance, and as effort by the petitioner and the further proceedings of complaint case, here case number so and so presently pending before the Court of Learned CGM, Sunitpur Tezpur shall remain state till the returnable date.
The impugn order of cognizance may be stayed.
Sorry, the impugn order, sorry.
The impugn
And the impugn order.
order.
And the impugn. If it is no sanction, then there is no sanction. Further proceedings. Further proceedings of complaint case, so and so, presently pending order, so and so, shall remain suspended till the return.
Alright, so item number 11.
Ma'am, but by way of this petition, we are challenging the proceeding. My lord, there are two petitioner before the lordship, my lord. Petition number 1 is son, and my lord, petition number 2 is father. My lord, here. So, lordship may turn page 22 is the FIR.
Yes.
May I read, my lord?
Hmm.
With due respect, the informant begs to state that with regard to my marriage on 22/1/2019, an agreement was executed in between me and accused number 2. Accused number 2 is my lord, father of the petition number 1. Before the-
Number 2 is present.
Yes,
It's been less than about 2
on age, where is a pleading?
Mainly, so.
You should point out to the court what order on the last date the court has passed.
Sorry, so actually forget my. Sorry,
You should have pointed out
my lord, yes, sorry, I have not.
that was your first duty.
Lordship, yes.
Some panel is there.
Yeah.
Okay, let us appoint Atal Tiwari. Heard. Mr. K. Rahman, Learned Counsel for the Petitions. And Mr. M.P. Goswami, Learned Petition Public Prosecutor for the Respondent State Assam. Respondent number 1, State Assam. Full stop. There is no representation on behalf of the respondent number 2 today on call. Full stop. Therefore, comma, in deference to the previous order dated 9/4/2025, comma, this court deems it proper, comma, in the interest of justice to appoint Mr. Atal Tiwari, Learned Counsel from the panel of amicus curiae, to represent the cause of the respondent number 2 in this criminal petition. First stop. Where the name of Mr. Atal Tiwari, Learned amicus curiae, for the respondent number 2 is to be reflected in the respondent side of list. First stop. The registry to furnish the necessary case papers to Mr. Atal Tiwari, Learned amicus curiae, so appointed within a week from today. Lays the case on 8 August.
Second week of Melody.
Within 1 week, registry needs some time to prepare. Thereafter, he has to prepare also. 8 of August.
Obliged. Item number 12.
Civil agent. Yes.
She was convicted under 138 of NA Act.
Mhm.
She was convicted, my lord, under 138 of NA Act, my lord.
138.
Yes,
Okay.
my lord. Yeah, my lord, what-
Then thereafter,
my lord, now-
affirmed in appeal.
Yes, my lord.
Okay.
Now, my lord, petitioner is on, my lord, in settlement, my lord.
Hmm.
Yes, just he wants some more time.
What is the additional amount?
Take amount was 10 lakhs.
Hmm?
Take amount was 10 lakhs.
10 lakh. What is the sentence?
11 lakhs and 6 months of.
11 months, 6 months. 11 lakhs and
Yes, sir.
6 months. In default or what?
In default, that's not in default, my lord.
Okay, pay 11 lakh, we'll decide about the sentence.
I will pay, but only it's,
How much time you require?
my lord, he had told me the.
Or we can send it to the mediation.
Yes, sir.
This nationwide mediation process is going on. Let us see the SOP. The mediator will be appointed. The Supreme Court has
Aye.
initiated nationwide mediation process. There is a scope for settlement. কোর্টে পারেন নাই কোর্টে পারেন You read this SOP. After 5 minutes will.
Item 13.
May it please the Lord. My lord, against an order of acquittal, an appeal was prepared before the Honorable Sessions Court. And there was delay, my lord, and the delay was not compound, my lord. That's why I have come before this Honorable Court by way of revision, my lord.
Delay was not counted.
My lord. Not entered into the merit of the case. My appeal was never registered. Page
Miss
29,
case, where is the order, impugn order?
page 44, my lord.
Forty-four.
44, my lord, Annex 3. Married.
What was the offense alleged or charged?
My lord, 325. 506.
Where is the judgment?
Judgment, my lord, you will find it, page 17.
Four four eight three five two two nine four five zero six.
My lord,
What is 352? 352 is force or what?
my lord. Two is, my lord, assault, punishment for assault or criminal force. Otherwise than on grave provocation. Punishment for assault or criminal force, otherwise than on grave provocation.
So what is the period limitation under section 372?
My lord, under 372, my lord, there is no specific period of limitation. my lord.
So judgment was delivered on
On my lordship. 9/2/2023.
9/2.
2023.
2023. So 90 days will go up to
Up to my lord,
90 days. Go
April,
up to,
April, my lord.
how can it?
April 30.
Have you done the homework or not?
My lordship,
Not 3 months, 90 days.
90 days, my lordship. 30. Arts 23, my lord.
Should be my lord 13th of May, my lord, 2023.
Here, keyword. Who else here? Keep going. Wait, wait. Mr. Das, you provide a chart so that it is for us. Go through the certificate copy of the judgment also from the appeal. Calculate, keep short chart, then we can decide. May or April, May undergoing treatment, something like that. Yes. It is a statutory appeal.
Well, you know, 90 days is a thing from, as per section 672. Even 114, A of the limitation of payments, right, only, period of 90 days. Only in case of appeal against the Indian by this government. So this, 372 subsection A, seconded by the government, the year 2009. It's a new provision. But that 90 days period is the application of 72 A.
There are many exhaustive judgment on 372.
Yes, my lord.
Should I
No,
get it or you should get it?
I'll get it.
Get it. Because 372 is meant for generally,
Generally,
meant for order appeal against acquittal.
appeal against.
Yes, inadequacy is there, inadequacy of sentence, but otherwise all these judgments are against order of acquittal.
Equity.
So what provision and other provisions of limitation act, period of obtaining the certified copy is to be excluded. So give the calculation.
I have given that calculation.
And what is the judgment of on 372?
372, my lord,
Come on Thursday.
I stay, my lord, 24.
Oh,
My lord, can it be on Monday, my lord?
I don't know about Monday. At least I am sure of Thursday, so that is why I proposed. Otherwise Monday. Okay.
24, my lord.
Okay. Mr. M.K. Das, Land Council for the petitioner, and Mr. M.K. Sharma, Land Council for the respondent number 2, are present on the prayer of Mr. M.K. Das. Mr. Das, Land Council for the petition, is vacation Monday. When is it? When is it?
My lord. Briefly, I will listen.
You give in a page, one page.
One, two.
I will not go through all the dates. You give me the dates.
Yes, my lord. Briefly, I will.
Item 15.
Salimul Islam. Yes, they shall be returned for updating. But
Hello, give the one, I will take instruction, my lord, regarding the maybe case there. Kindly up to my lord. Here, my lord.
up to date case diary.
My lord. Is from disposal.
You will get the case diary. And two.
Is my lord directed to retain my lord. Maybe now.
Case diary shall be returned for updating. That is the order.
Well, I will hear my lord.
Well, this was a Jimba order also in this Melod. In this petition, one Jimba order also impugned here. Well,
Let him. I am not adjourning it.
not. Obliged.
Item 16.
Councillor Mr. S. Bothakur will appear in this matter. He is on legs in court number 1. So may kindly pass out the matter for timing.
You are enjoying interim order.
Yes, Your Worship.
What kind of interim order? You are enjoying interim order on the prayer of Mr.
Speak authority.
Release the case on so and so. 25/7. The interim order passes shall continue. Mr. A.K. Google. Land Council for respondent number 2 is in attendance. 28.
Lordship,
Interim order.
Mr. Bothakur will out of station on 28th. Lordship. Can it be in on
30.
12th? 12th. Lordship.
Huh?
12th of
Not 12, 11.
Lordship. He won't be there till 11. Lordship. Yes, Lordship.
13.
Item 17.
After some days, yes, use another court.
Service report. Let me see. Yes, you have entered appearance.
Yes.
Okay. Okay, this is for what?
For washing the intercourse again.
Okay. Yes, Ms. Sharma.
Team here, although DCR has been received, some vital documents were not in the record, so reminder was sent for, but as far office not yet received.
That would be 1970.
1970. B. Sharma, learned Ramakashpur for the appellant and Mr. M.P. Goswami, learned additional public proceeding for the respondent group. One, from state of Assam are present. Here is the office note dated 19/6/2000. In view of the office, state office note, comma, place the case after 2 weeks for a report as regards receipt of the documents in terms of the order dated 11/6/2023. Yes, Odananda. R. Hussain perused office note as well as has received the relevant records. Minor victim informant removed. Service report.
Your lordship, kindly see the office note dated 26/2025.
He is saying he'll need some time. How much time? Goramur. Which district?
Jorhat.
Mr. R. Hussain.
Yes.
Learning counsel for the appellant is present. Post of Mr. M.P. Goswami, learned additional public prosecutor. Paying for the respondent number 1 state has sought for a week's time to obtain and place a report as legal service of notice from the officer in charge, Goramur Police Station. Place the case accordingly on the date to expire.
Item number 20.
So you are making a appellant. It was sure. None has appeared. You're there. For the applicant appellant today on call, Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1 state, and Ms. D. Pujari, learned legal aid counsel for the respondent number 2 are present. In view of absence of the learned counsel for the applicant appellant, laid the case for ensure justice will instead of 2 weeks and later expires. Babu. Because you should take instruction. Yes, Miss Officer in charge. Bihu board. Received?
Not received.
See, but I hope that you appear soon. You know what's there. No? Miss? Miss? Your name, please.
A Khatun on behalf of Madam. A Khatun.
Khatun. Learned counsel. On behalf of Miss A. Burman.
M. Bol.
M. Burman. Learned counsel for the applicant. Appellant is present. Mr. M.P. Goswami, learned additional public prosecutor. Applying for the respondent number 1 state of Assam has submitted plans. Has sought for a week's time to obtain 10 days time to obtain 2 weeks time to obtain a report from as a service of notice upon the opposite party in respect of 2 press informant from the officer in charge, Viewer Police Station. The appraisal of the case after a week, after 2 weeks. Or to enable the learned addition public prosecutor to obtain and place a report as legal service of this. Respondent number 2, press informant.
Item 25.
That will say lordship. And then measurement be taken at 2 lordship. Criminal is in.
It's not, it's not by the state has to take it, that's the company.
25.
What? Today we are for higher lordship and steps have been taken.
What offense?
Lordship.
376.
376 lordship.
You are seeking passing.
Washing lordship. In this regard, lordship,
Cardinal Pissas.
Supreme Court judgment also there, lordship, that victim girl is not ready to continue that case, lordship.
Huh?
Some amicable settlement has been done, lordship.
But then that person has to be served.
Definitely, lordship.
Huh? That is not there. Have you taken steps?
Lordship, in respect of criminal petition, we have taken a step, lordship. IL lordship.
You see.
In the trial procedure, lordship, NBW has been.
Admitted issue. Sir, you have not taken steps for service of notice of the respondent number 2 in the main petition. How can you raise an interim order in the IA
In respect
when
of
you
the-
are not
in respect
obeying
of
the order of the
petition,
court?
We have taken a step, lordship.
No, it is not there.
IFR lordship, NBW has been issued, lordship.
No, when you have filed a criminal petition, you were directed to take steps, but you did not take steps.
We have taken.
No,
Okay, lordship, we will take a step and, lordship, kindly, the IM may be fixed shortly, lordship.
but you take the steps, right? On the respondent number 2. If he comes and says that matter has been amicably settled, then in the light of the observations and the facts of the case are to be examined.
Definitely,
What Supreme Court has said, we will examine, plus the facts of the case.
definitely.
Mr. Islam,
Yes.
Mr. M.A. Islam, the counsel for the petitioner, has submitted that the petition be granted 2 days' time to take steps for service of notice upon the respondent number 2. Mr. M.P. Gussamil, additional public prosecutor for the respondent number 1 for state of Assam, has submitted that state has no objection in the very allowed. The petitioner shall take steps for service of notice. Shall take steps for service of notice upon the respondent number 2 by registered pursuit AD is allowed. The petition is allowed to 2 days' time, 2 working days' time to take steps for service of notice upon the respondent number 2 by registered pursuit AD. This is the case after 3 weeks.
Lordship, what date may be given, lordship? NBW has been issued, lordship.
Place the case on. Fixed it. 3 weeks.
Item 26.
Tips for call for scan copy, issue notice, returning, respond number 2. Who is respond number 2? NDPS. NDPS,
Yes, can be awaited in service.
both awaited. SCB SAS, Land Council for the petition. Heard, our Mr. M. Nicholson, for the state. Postal. Await for the service report in respect to respond number 2. As well as the skin copies of the TCR is the case after 2 weeks.
Something to list. Item 41.
There is no representation beyond the petitioner. Please, I guess, on a date in the next meeting.
timing is this, I don't know, 12. Like a word for you, let's see, but they was mine. It's making people the last meeting. In 7. Can be said about 7.
Hmm?
So, like,
Timeline, 31st July. We're in July.
third page, I believe.
Action by the High Court. All matters having element of settlement. That it can be done. Okay. Heard Mr. S. Hawk, Learning Council for the petition, and Mr. T. Devi, Learning Council for the respond number 2. Who is 1? Okay, MP Goswami, Learning Additional Public Prosecutor for the respond number 1, to State of Assam, and Mr. T. Devi, Learning Council for the respond number 2.
No, state is not a party.
State is party. Party. Here, मेरे party is 2. Goes to. The respond number 2 hearing, as the complainant had instituted a complaint under Section 138 Negotiable Instrument Act, alleging dishonor of a check amounting to
10 lakhs.
10 lakhs. Goes to. And the said complaint was registered as complaint case number
3 of 2019.
Where is the page?
Page 11.
Page 11. 21, I think. Say complaint petition was registered as CR within bracket and full stop I, full stop bracket close. Case number 03/2019. Before the Court of Planet Subdivisional Judicial Magistrate within bracket M, comma 5. Full stop. After trial. Comma. The said complaint had resulted in a judgment and order dated 1/11/2022. And by holding the accused hearing, that is the petitioner hearing guilty for the offense under Section 138 and Act. Full stop. The trial court has sentenced the petitioner to the trial court judgment is there.
Page 11.
Page 11. Last page. Second, last page.
Sentence, the petitioner is sentenced to undergo simple imprisonment for 6 months and to pay a compensation of rupees 11 lakh to the complainant. That's respond number 2. Full stop. The appellate court in criminal appeal number 21/2000, appellate court of Learned Sessions Judge Kokrajhar, in criminal appeal number 21/2022, had affirmed the judgment and order of conviction and sentence of the trial court, while a judgment dated 15/2023. Hence, the instant criminal revision petition. So, Mr. Hawk, Learned Counsel appearing for the petition has submitted that the petitioner is making a efforts to compromise. Full stop. Mr. Deori, learned. Council, Supreme Court response number 2 has submitted that the response number 2 is agreeable to receive the compensation amount. Full stop. This court is of the view in view of the above submission made by the Grand Council for the party. This court is of the view that there exists an element of settlement. So substantially in view of nationwide settlement is first date 31st July. By any division, which is it. Right. Mediator, you contact the mediator. Right. His phone number, email ID will be there in the order. Right. I don't know, 17.
Please, your lordship.
Service report awaited is the matter. Yes, appeared.
Lordship. Lordship, and there the husband and wife, lordship, and some dispute is arise after getting the marriage, lordship. And subsequently, affair was lost, lordship. And but now the government is not be interested to continue this case. Lordship. On that basis, lordship, I file this petition.
What is the offense?
Lordship. 420 and 420, 344 and 366 are also lordship.
Introduce, this is the FIR, page 11.
Lordship. Page 11 is the
The respondents.
It's Pulashwari Musawari, respondent number 2.
2. I introduced so Simantopuro. You are Simantopuro?
Lordship.
What translation you have made? I could not understand.
Lordship, some.
Huh?
Some.
I have to go to the vernacular now.
Lordship, may I, page number 16, lordship. I'm sorry, lordship, some,
Modification of English language.
no.
Huh? This is also illegible.
Lordship, may I read, lordship? I have to agree with this is like.
Yes.
Chief, at the sisters, I'm very important.
Yes.
At this business, lordship, I'm not interested to proceed the case, lordship.
Submit an affidavit. Submit an affidavit. That you are agreeable. Therefore, tomorrow we'll fight it.
How lordship, we're living separately, that's brilliant, but have communication. But now, we're living separately, but have communication.
Communication.
Yes, lordship.
While living separately, but we have the relation, lordship. But no dispute at all, arose.
I could not understand the affair.
Affair is lordship.
What is this? Marriage card?
Marriage card.
Yes,
Huh? Marriage was solemnized.
Lordship.
Marriage was solemnized.
Sorry.
Then what happened?
Is the para number 5, page number 4. lordship.
Oh, this after FIR it was solemnized.
Lordship.
And what was the offense for which it was registered?
420, 344 and 366.
Okay. She was a major.
Measure.
yes.
Submit the affidavit.
Yeah, I will get it.
Nothing there. F of Land Council for a petition, Mr.
petition of
MP Gusari, Land Council for Respondent, State of Assam are present. Yes, Mr.
Alim Sheikh Lordship.
Alim
On behalf of
Sheikh.
Mr.
Land
Yashwant.
Council. You are not there in the case.
Yes, Lordship, on behalf of Mr. Yashwant Lordship.
You have not filed local nama.
Lordship, Yashwant must file local of Nama Lordship.
Okay, on behalf of Mr. A. Sharma, Land Council for Respondent number 2 has submitted that the respondent number 2 will file an affidavit on by Thursday. Thursday. So release the case on 10th.
On hearing. Item 27.
Can I accommodate today? I have some personal equity in the second half.
Okay,
I have told my friend yesterday also that.
okay, okay.
So not can it be? So will be for-
Choose a date in the next week then. Next week or day after.
Just a minute.
420.
No, this was my lord conviction under 420 and 409. Lord, my basic argument, my lord, in both the sections on the same set of facts, my lord, conviction cannot be sustained. And this,
Yes, Mr. Kotogi, choose an agreed date. 2009 matter.
yes, true, my lord. That's what I have not made a mention in the morning, my lord.
What kind of 420 and 409?
No, no, this was a my lord transaction relating to share reeling.
Can it be under mediation?
My lord, I have told him, my lord, that I am ready to pay money.
That
With,
is why
with some interest.
Supreme Court has
with-
initiated a nationwide mission.
I understand.
So,
I
whether
have
it
said
is.
that I'll pay some interest also.
So,
It's not that, my lord, and my age, my
if
lord,
a
I'm-
mediation under a trained mediator,
Yes, but.
the parties may come to an agreement, possibility is there.
Lord, even my lord, my friend can do it, my lord. No,
Yes, Mr. Kotogi and Mr. Agarwal can
You
decide.
know, my lord, I have discussed with my client is ready to pay the amount.
Yes.
80,000 plus some interest, my lord. From that date till date, my lord. I
May-
have conveyed, my lord, him.
They are also relatives.
They are
So,
relative.
if you are there, online, offline, every mode is available.
My lord, mediation is not required, my lord. He may be able to do it.
Let them
He is
He may be able to do it.
because between the relatives.
I have
some
told him,
issues
my
are
lord,
there,
what is the, my lord, in my lord proceeding the matter and putting him behind the bar.
The parties are from which place?
My lord, my client is from Delhi, but my lord, his client is from Lamding basically. And my lord, both are
And,
related.
no, in the mediation, online mode is available. Parties can directly with a mediator can contact and clear. Both are all modes are available.
Probably, my lord, I am making a small suggestion, my lord. Let him try first, my lord. Promise.
No, by that time this mission will be over.
Oh, I shall soon be done.
No, nationwide mission is initiated. So under a trained mediator,
It is better another train mediator.
then your negotiation skill is not required.
No.
Mediator will
Mediator will. Yes. Let it be.
let it be.
Because we put the relatives, so there's many issues are there. That's why I don't want to enter.
So a neutral person will be there
Yes.
as a mediator.
Let it be.
Choose a date.
Yes,
Online, offline, so लिखित बोलो बोले. बोलिए online, offline लिखित बोलो. Date you can choose. Heard Mr. K. Agarwal, Learned Senior Counsel, estate by Miss
From a senior.
P. Neo, Learned Counsel for the petitioner, and Mr. P. Kotogi, Learned Counsel for the respondent. Custom. Having had the Learned Counsel for the parties, it transpires that the bone of dispute, bone of contention,
But I think to purchase of
Yes.
shares.
is purchase of shares.
Yes.
So it is the dispute, in a sense, It's a commercial dispute. Because it is
Yes.
a full stop. From the submissions of the landed council for the parties. I am putting the blame on me.
No,
There exists an element of settlement. Full stop. Mediation dates. When they can. Online also.
Online, my
Online.
party may not be able to.
Online,
cover
online.
the bedridden.
Online is permissible. Okay, लिखिले हो जाने का लिखो. The standard operating procedure permits the willing parties to appear and proceed to the mediation process either in offline mode within bracket physical mode or in online mode or in hybrid mode. Full stop. The first date of mediation is therefore fixed on Tuesday date.
18th of August for 19.
Prior to that, it is online. You can appear online. Does not require on the first day to come to Guwahati. So it can be earlier. 1st of August,
First of all, yes.
1st of August.
1/8/2025.
1st of August.
For the purpose of further reference, the party shall contact coordinator stroke nodal officer of the mediation center, so and so, mobile number so and so, email ID so and so. Release the case after report of the meeting. Huh? Let us see.
Yes. Okay, yes.
All pending, that can be settled. Mediator may persuade.
Yes.
That's all.
Which Mr. Agarwala and Kotogi.
No, I have pursued my client. He will.
Mr. Kotogi is not agree.
Kategi has not been able to. Will.
Epoch.
Wait, please, Lord.
Yes, sir.
My lord, the revisions against the conviction, my lord,
Conviction.
conviction. 6 months, my lord, for railway property, unlawful possession of railway property. My lord,
Unlawful position.
Possession, railway property.
Hmm.
Another railway property, 3A of, I've been convicted.
Concurrent finding.
Concurrent finding. Well, I cannot go for the facts, but I have to be with the law. I have been convicted for 6 months. Now, there's two questions which are before court regarding some legal aspect. What
What is the offense actually?
offense was what? A truck was being
No,
found.
no. You are convicted under what section?
3A of the railway unlawful railway property act.
3A.
3A. Unlawful possession act, 1966, 3A,
3A. And you have been sentenced for
6 months.
6 months.
6 months.
Did you undergo any period?
Yes, I have undergo, Milord.
How
almost
much?
70 days, Milord. Now,
70.
11 year, 2007 matters, Milord.
70 days.
70 days almost. I don't know, it will be in this thing. What I was on, this 2 point, what I raised before this,
First, you tell me how much period you have undergone.
I think 70 days.
Railway property unlawful.
Yeah,
Page.
50 days or 50 days or 60 days. 3A. There's 3A and 3B. If it is a second offense, will not,
Well,
Now there is, so for the 3A, 3B, difference between 3A and 3B. is
3B is different, subsequent offense.
Subsequent offense. So for the
So
3B
for you, it is first.
First, not subject to that if your lordship, but if your lordship finds that I am guilty of them, that 360 will apply, may apply in so far 3A is concerned. But so far
Whether
3B
the trial court has recorded any special circumstances
no,
to give it below, to keep it below 1 year?
no.
No.
Only things, there are two aspects of the matter. Is this. On what basis I have been convicted? What has
Okay.
happened? There are two cases. The first one has happened, Nahakute PS, my lord. In front of
Then
the
we'll start with a fresh mind at 2 o'clock.
man. So matter, I
Yes.
just simplified your lordship, if your lordship want to, because I have already been in jail. Just short point, I have just, one is, there are two cases. First, Nahakute PS case has been registered as 379 full work. Then the railway comes, my lord. And they have, my lord, 3A, two subsequent cases. I have been, because
So you were found in possession of what?
screw, my lord. Because
Screw.
Screw.
Real screw, iron
Well,
screw.
Iron screw, 2,228 screws. In the, well, a truck was found standing before a dam. And the dam, there's a piece of irons. And thereafter, my lord, it was been seized by the Nahakute police and they have registered a case under section 379(4). So on 5th of, I think, 5th of January, the police from the railway police has come and want to search this as the absent of the SI, OC. They could not search this vehicle. Next day they searched and found so and so. Accordingly, they have also registered a case. They are also registered a case. Now, there is two cases cannot go together. That is number one, under 210 CRPC. One has to be stopped. And second, that has not been considered. Second, the exhibit 18, which has been
210 is, I think, police case and complaint case.
but here two cases, on the same offense.
Case is,
210 is one is complaint, my lord.
meaning there were 2 FIR
Two affairs, two cases,
for the same set.
same thing.
Huh.
Once has proceeded.
So what happened to the police case?
The police case, I do not have any idea so far. At that point was been raised before the trial court, I think, what I get to know about from the appellate judgment, my lord. And second is what? Exhibit 18, while I was in jail, my statement was recorded in front of the jailer, in the jail. And that has been exhibited as the exhibit 18, my lord. That is one of the issues, my lord, which led to my conviction that I have confessed. Now, whether the exhibit 18 is taken to be a 161 statement or that can be read as a 164 statement and then exhibits.
164 statement can be exhibited.
My lord, now.
Right.
No, so
And 164 statement can be used
exhibit,
both for the purpose of corroboration or contradiction.
contradiction. No.
161 also can be exhibited as a disclosure statement
My lord.
for the purpose of
No, no.
section 27
So what about
or
27?
for contradiction,
Yes, my lord. But not others, my lord.
not others.
3A, my lord, that has been exhibited. That is my case.
Okay, we'll
So,
see.
well,
We'll see.
section
We'll try
27,
to see.
your
We'll
lordship,
try to understand.
That can be used over the section 27 is concerned,
27 is fine.
not beyond that. My lord.
But here the recovery is earlier.
Over is there, my lord.
So 27 will not come.
It's not a.
There cannot be.
There cannot be, my lord. I have to lead.
recovery has to be subsequent to the
Subsequent,
statement.
I have to lead, my lord. That has to be
Yes.
discovered too. And that has to be, my lord, statement has to be recorded. Recorded means whether it is by, that to depose to. My lord.
That has to be
that is
deposed to.
deposed.
Oh, yes. But here you have said that seizure or whatever recovery
My lord.
of screws were first.
First,
So thereafter arrest, thereafter statement.
statement.
So
That too in jail,
27 is out.
out. So, but that too in jail in front of a jailer.
So it could at best be by the IO,
Right.
means it is 161 only.
Okay. Once it-
On 161 only for contradiction.
Contradiction, corroboration, whatever it may be.
No, not corroboration.
No,
No corroboration.
Uh,
Only contradiction.
Contradiction.
Okay, let us see.
My lord.
Okay, we'll hear Mr. Bora.
No, only
some
thing,
time.
what I say is,
We'll
already,
first-
almost 19 years.
First, I have to examine why this case is pending from 2012.
No, how, not because of, my lord.
For that, we have to
Your
understand the
lordship,
submission
see
of
what
Mr.
my learned
Bora.
friend- nah, what my learned friend has said, I object to that. It is not
No,
because
no,
of
we are
me,
not
I
taking
did,
it.
my lord, in the
We'll
record.
we'll
will show-
hear you, Mr. Bora.
No, whenever you stated before a court, not, you should be very reasonable and being.
First, we will try to understand.
Not because, no, no.
No, leave aside all this.
No, that I cannot
Ah.
accept this one, that
No.
because of me, that this case has been, it's not that. He should be careful while stating.
Everybody is a contributor.
No, definitely.
Board is maybe also.
Maybe also, I am not saying, though I can say. because
Anyway,
I
leave
am not-
aside, we will hear at two. Okay, thereafter, if it requires, we will accommodate. We'll accommodate.
Man,
Item number 25, my lord, my junior appear, I could not appear, my lord, I went to one senior administrative tribunal, my lord. Then, Mr. My lord, your lordship passed the order for fresh step, but already step has been taken and there is an urgency, my lord. Because during pending of the criminal petition, my lord, I has been filed for suspension of the NBWA. That has been passed by the lower court. And here the matter is here, my lord, the criminal petition has been filed for quashing of the FIR. The victim girl already has.
Order has been passed to release the case on something without I have already signed the order. All the orders.
My lord, there is an urgency, my lord. Next week, my lord, if the matters can be taken up, my lord.
Suppose you sign to do so. 25 is suppose you don't have to
25, my lord.
Item number 15, my lord.
Always.
Case diary, my lord, I have enquired, my lord. Not received, my lord. Kindly have a date on next.
15,
Can it be Friday, sorry, Monday?
Monday, next.
Monday. K. Raman, petitioner present. On the prayer of Mr. A. Sharma. And additional public prosecutor gave the case on so and so. To enable him to produce the consent case diary. Let us have the trial court judgment.
my lord.
Then we can understand.
Yes, my lord. Just, I'll just give two things you have to go into. The three things which lordship has to be, because they're revisions. So I have
Yes.
to be on the question of law.
Legally propriety.
Yes, and on the substantial question of law. Number one is this, that whether your two parallel case can be on while registering case and simultaneously proceeding has been started. That is number one. Number two, that whether the exhibit 18 can be taken into the considerations, the statement which has been recorded was not in, can be a ground for conviction. That is number two. And number three is this, that defense witnesses. Number one, has not taken into account. So these are two things.
Only after reading the
Yes,
judgment.
yes, definitely. So my lord, I'll,
Okay, I'll read the judgment then.
mm,
Page,
it's a page, my lord, 12 onwards, my lord. So may I read, my lord? The case of the prosecution is that on 4/2/2006 at about 16 hours, the complainant received an information through the in charge of the RPF Nahakutia regarding the interception of one truck bearing number so and so at Gatupatar, Nahakutia in front of a scrap dam at 3 hours by the oil security of Duliajan under the supervision of SI Box. Some cut pieces of oil pipe were loaded with other stolen materials and 13% were also arrested. On getting the information of the complaint along with SI G. Gogoi, Constable M. Medhi and Constable P. Khatune left for Nahakutia on 5/2/2006 for conducting an inquiry at the Nahakutia police station. On arrival at the police station, the complainant served a written memo to check the truck. But due to non-availability of officer in charge Nahakutia, the investigating officer did not permit the truck to be checked. On arrival of the OC at about 6:30 hours, the complainant was given permission to check the truck on 6/2/2006, which was seized in connection with Nahakutia PS case number 0926 dated 379 IPC. The case has already been listed. On 6/2/2006, the complainant with his staff attended the Nahakutia police station, checked the truck in presence of local police of Nahakutia and found 2247 numbers of rail screw busy in the truck along with the other stolen materials, which were seized by the Nahakutia police in their case. The rail screw was seized from the custody of Nahakutia police. The Nahakutia police arrested 13 persons, namely 1, 2, 3, 4, 5, 6, 7, 8, 9, 8, 9, 10, 11, and 12 is Orundubi, and 13 is the Deepak Gupta, the petitioner before also. All these 13 accused persons were forwarded to the jail during Soweto. Thereafter, railway materials were seized by the complainant and the case was lost. The complainant so lost registered as case number 1/2 under section 3A of the Railway Property Unlawful Possession Act 1960, in short RPUP Act, and SI Shri D.D. Das was entrusted to inquire in the case. During the course of inquiry, it came to the knowledge of the inquiry officer that the driver of the seized trucks, namely Shri Nagendra Roy, who has loaded railway materials without the knowledge of the owner. The inquiry officer tried his best to arrest the driver but could not do so, as he was absconded. From the findings of the inquiry, he submitted a prosecution report against so-and-so, 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 and so-and-so, and absconder accused Nagendra Roy. During the course of trial, the case against accused, namely Mohammad Kalam, Alap, so-and-so, 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 and were separated as it was reported that the accused persons were not available in their given addresses. However, accused Deepak Gupta contested the case till its completion. On the basis of evidence adduced by the prosecution witnesses charged under Section 3A Railway Property Unlawful Possession Act 1960 is read over and explained to the Deepak Gupta, to which he pleaded not guilty and claimed to be tried. The prosecution examined 13 witnesses to bring home with charges which include the complainant and the inquiry officer. These witnesses were cross-examined by the defense. The accused person was examined under the Section 313 of the Criminal Procedure Code, wherein he denied the incriminated materials against the so-and-so. I have heard the ladder so-and-so. I skipped my lot, this one.
Yes.
The point of determination number 1, that whether the accused person can be held accountable for the unlawful possession of the seized railway materials, whether there exists reasonable suspicion of the involvement of the accused person in stealing the materials from that section of the railway. Number 3, whether the prosecution could prove its case beyond all reasonable doubts. In case of prosecution, admittedly based on the receipt of the information of the truck which was intercepted contained railway materials amongst the other materials loaded in it. Based on information, PW1, Sri Divesar Musahari, PW4, Montu, PW5, Prosenjit Khonikar, and Girish Gogoi went to the Nahakutia police station and after observing police seized the railway materials, which were rail screws numbering 2247. Among the other materials present in the truck, which were primarily materials belonging to oil, the RPF staff took portion in extracting only their concerned railway materials without any kind of bias. PW3 Rupam Chandra Sadarika stated that PW6 Rupal Chandra Bora, who belongs to the oil security division, came to his quarter and showed him a screw as a sample to ascertain if it belonged to railway. On being confirmed by the PW6, the witness and one of his colleagues went to the Nahakutia police station and personally verified the loaded truck and saw some rail screws where, along with some pipes belonging to the oil. PW3 then intimated the matter to the inspector RPF at Moriani, along with PW1 13, went to the Nahakutia police station and separated the rail screw from the truck and found 2247 of the screw. PW 13 also stated that he saw some 13 accused persons arrested in connection with the case at Nahakutia police station. PW6 Gopal Chandra Bora intercepted the truck which came out of the godown of Deepak Gupta and which contained the rail screws. He deposed honestly that the inside the truck accused Deepak Gupta and 10-12 laborers were present. In cross-examination, the defense totally failed to bring the fact that the accused was not found in the metal, found with the metals. Some wayward questions were asked. The defense by the asked and failed to invoke
So
the
this petition was found inside the truck.
Well, that is a allegation, my lord.
No, PW said, 6 said
he was in
It
the,
deposed honestly that
Ah.
inside the truck accused Deepak Gupta and 10 to 12 laborers were present.
my lord, what? he
This is his
stated-
deposition.
Deposition, can you see the deposition? I'll show the deposition. Minutes. So then, in the cross-examination, defense totally failed to bring the fact that the accused was not found in the materials. Somewhere, questions were asked to the defense. Now, if your lordship, there's two queries, whether the screws were railways or not, that is also questionable. my lord.
That
Because
we'll
the
see,
screw-
we'll see that. The three questions, we'll see to that.
My lord. Failed to invoke the innocence of the accused. PW10 Deepak Kolita was posted at the Nahakte police station when PW6 had handed over the railway materials and accused person at the police station. He had duly recognized accused Deepak Gupta in the and stated that he was present along with the truck. In the cross-examination, the defense again failed to prove that the question relating to RPF personnel present at the scissor or the size of the screws, but failed to bring the perspective that the screws found from the possession of the accused did not belong to the railways. The screw, the cross-examination, kindly see the cross-examination, that the screws found in the possession of the accused did not belong to the railways. PW3, Girish Gogoi, an inquiry officers stated that he was also present with PW1 when the rail screws were separated and seized. Nahakota police station, he stated that the 13 accused persons were arrested by the police and among the Deepak Gupta also figured. He stated that during his course of inquiry, he had recorded the statement of the accused person of the Dibrugarh jail in presence of accused jailers. Straight, and during the statement of accused, he has pleaded their guilt in the case. The finding of the inquiry officer showed no anomalies and report submitted him is very much believable. My lord,
Now, what is this inquiry officer?
my lord, inquiry officer is not, he is the,
This offenses under the Railway
my lord, kindly see.
Act.
Number one.
Number
One, first of all, your lordship has to see that whether this property belong to railway or not. That is my, not
see,
that is the.
my query
My lord.
is that under this act, what act? What is the name of this act?
My lord, name of the act is
Railway property.
railway. No, my lord.
Railway property unlawful possession.
My lord. My lord, who is an inquiry officer? He is an RPF, my lord, inspector. Whether, my lord, will kindly appreciate whether this material is belong to the railway, how he can assert it?
No, this act, it looks like
My lord.
it speaks of inquiry, not investigation.
My lord. My lord.
There may be some differences, right?
My lord.
So I don't know, I have not gone through this act or I have not adjudicated any
Right.
matter with regard to this act. This is my frank submission. Now, it contemplates inquiry, not investigation.
Right.
So that is what the
Yes.
difference is.
Yes, sir.
So Section 8.
My lord. Inquiry how to be made.
When an officer of the force, means I think Railway Protection Force.
Force. This is RPF.
Railway Police is different and Railway Protection Force is different. And this man, I think is from Railway Protection Force.
No. It's from police, my lord. Railway police. Can you see, this is 13. Here's a 11, 12, 13, my lord. A protection force at RPF outpost. It is an
Huh?
RPF outpost.
Which line, which line?
My lord, it is in the deposition, my lord. He's been examined as PW 13.
Which line? Page.
My lord, his statement on 4/2/2000.
Page.
Oh, it is not page, it is from the record, my lord, it's a. My lord,
And he is from RPF or Railway Police?
my lord, what is that? He's an SI. RPF in Chuki.
RPF. Okay.
RPF, Railway
Okay.
Protection Force.
1 minute. Force means Railway Protection Force. Okay.
Force means Railway Protection Force.
When an officer receives information about the commission of an offence punishable under this act, or when an officer when any person is arrested by an officer of the force, foreign offence punishment or is provided to him into the charge.
Inquiry. What?
Inquire.
Inquiry. Now, well, number one, if your lordship kindly see the inquiry report and he doesn't mention about the screw belong to the railway or not.
Now we'll go to that. First, understand what is investigation and what is
Inquiry.
inquiry. So.
He made an inquiry.
No, investigation, there the provision of 161 comes, right?
And
In
inquiry-
inquiry, it may not come.
My lord.
I have to look into that also.
Yes, my lord, there are two different things. One is inquiry and one is a statement recorded under 161.
Okay, let us continue again from this last paragraph of page 14.
My lord, 14. My lord,
PW 13.
13. Girish Gogoi is the inquiry officer in this case. He also present with PW1. When the rail screw were separated and seized at the Naharpete police station, he stated that 13 accused persons were arrested by the police, and among them, Deepak Gupta was also figured. He stated that during his course of inquiry, he had recorded the statement of the accused person at Dibrugarh jail in presence of assistant jailers, and during, well, I don't know what the word is being said, sorry, my lord. Jailer at, and during the statement, accused person has pleaded their guilt in the case.
Just stop. Now, section 9.
My lord, 8 and 9, my lord, your lordship, power to summon to give evidence and produce documents. Now,
Section 9.
9 and 8, how to conduct it. Deal 3. Inquiry.
Same power.
That an officer of the force shall have a power to summon any person whose attendance he considered necessary either to give evidence or to produce documents or any other things in the inquiry which officer make for the purpose of the act. Number 2, a summon to produce the documents or other my lord, or other things, maybe for the production of certain specific documents or for the production of all documents of those is certain. Description of the possession or under the control of the person summoned. All person so summoned shall be bound to attend either in person by an authorized agent or as such direct, and all persons so summoned shall be bound to state the truth upon the subject respectively so and so, provided the exemption under section 132 and 34 of civil procedure.
This part, interpretation of this particular subsection.
My lord will find what has happened in this case. Now, there is two things. 8 say how to make an inquiry. Not investigate, inquiry.
Okay.
And 9 is inquiry officer summon the person.
Hmm.
Now, what has happened? My lord, inquiry, I am in jail. You know.
Right.
I am in jail. Now he has gone. Now whether to the jail. Now whether this act provides or not. That is number one also. And the statement which are recorded are in accordance with law. These are the statements. Because there's another things I will just point out.
This part,
I will just point out one thing. The person will belong to a Hindi speaking. What is stated in the evidence, he speaks and he said that I write in a service.
that is a matter of
But
preventive detention principle will not come.
no, but only
Preventive detention principle will not come.
detention is a sin. My lord, that has to be.
There,
When I speak in Hindi, my lord,
is there any interpretation by any authority, precedent, that all persons so summoned shall be bound to state the truth upon any subject respecting which they are examined
my lord.
or make statements? I'm on that. If that Justice Rohington Nariman's judgment, which one? Mukesh or Supreme Court judgment, that other than police, customs or
Well,
NCB, narcotics or enforcement, they are also to be on the same footing to spring the rule of evidence under section 25
well,
of the Evidence Act into action. Meaning thereby, any statement made before them is not admissible in evidence. Is there any authority on this part, the act?
my lord.
Have you understood what I am?
But
Because the trial court has observed that during their statements, accused person had pleaded their guilt in the case.
in that case,
And this might be one of the factors
my lord,
for the trial court to reach the verdict of guilt,
guilt,
right?
my lord.
So, like that
Yes,
case or what is the case?
My lord, in fact, I also forgot that was the case. But this NCB,
Because there also, it is complaint. It does not result into charge sheet.
my lord, even in the PMLA also, my lord, the
Right.
complaint file, there will be hard.
Similar, that is why I am
My-
making a query from Mr. Bora, learned senior counsel,
Definitely.
that whether there is an authority on this particular act regarding the rule contained in section 9(3).
But I didn't find, not to be honest.
Why? You can definitely find, otherwise we have to find.
I have.
Because so many railway theft cases are there. Yes, Mr. Tell me, as an officer of the court, nor as a prosecutor of the railway.
What I can say.
This is an inquiry, not an investigation. We are about quite clear that in an investigation by police, right, as per the CRPC, a person in custody makes an admission during his statement recorded under section 161 CRPC. That cannot be read into evidence
Yes.
because of the rule of evidence contained in section 25 of the Evidence Act. Now, interpreting it further, the Honorable Supreme Court, in the judgment authored by, I think, Justice Rohinton Nariman. NCB Enforcement Director, Customs Officer. That's section 67 was there in NDPS Act.
Well,
Earlier, the principle was that it is admissible. But it is not admissible. Which is the judgment?
well, I also forgot the judgment. You know.
I forgot the name actually. Mukesh. Mukesh Markson. Mukesh or okay, let us read further in the meantime.
Well,
We proceed from last line of
last line
paragraph
of,
14.
we're trying to keep it like, Eastern General,
Yes, findings of the
well, just a minute. But, last minute, he stated that during the course of inquiry, he had recorded the statement of the accused person at the Dibrugarh jail in presence of assistant jailer and during the statement, accused person has stated their guilt in this case. The finding of the inquiry officer to show anomalies, no anomalies, and the report submitted by him is a very much believable. In the cross-examination, the defense again failed to point out any kind of discrepancy in the finding of the inquiry officer. The prosecution in the case has succeeded in proving the accused Deepak Gupta was unlawful possession of the rail school. The prosecution as initiated by the RPF in the case against the accused is the result of cooperation made by the oil security staff and the Nahakutia police, and as such the possibility of any kind of prejudice against the accused is ruled out. The confession of the accused, Deepak Gupta, is exhibited by the Exhibit 18 is made in all fairness. The reason for justifying the fairness is solely because the statement was recorded while accused was in judicial custody and the statement was made in presence of PW 12. That is Sampakani Modlo, the assistant jailer, who is the assistant jailer of the Dibrugarh jail. When the statement was recorded, PW 12 in all her sincerely deposed that he heard the accused Deepak Gupta admitting that he had purchased the materials from an unknown person. The statements so recorded by the inquiry officer of the RPF cannot be excluded or discarded from the evidence because RPF is not deemed to be deemed police within the meaning of section 25 of Indian Evidence Act. What it stated, my respect submission is not like that. The statement recorded by the RPF inquiry officer is an equation of confession. The fact the screw seized by the RPF belong to the railway is undisputed because of PW 8 who examined the rail screw. Tufan Singh, Tufan Singh versus state of Tamil Nadu. Tufan Singh versus state of Tamil Nadu.
Same point.
My lord.
Page 15, third paragraph. Confession. Same point. He is saying RPF is not deemed to be police. I have some doubt.
They are protection force. They are force.
I have some doubt, and you are Mr.
No. I honestly.
You are a senior counsel.
Well, definitely, Milord. So far this is concerned, I could not get time yesterday, Milord. I hardly time. I just go this thing. These are the questions which I brought before the lordship. And these are the things has to be.
Because this observation, I have some doubt that RPF is not deemed police within the meaning of section 25 and more particular in view of Tufan Singh. Right? Because they are also NCP or enforcement director or customs. If they inquire into matter of contraband, possession of contraband, that results into complaint, not searching.
Yes, ma'am.
Right. Similarly, that was not investigation, inquiry. And it results into a complaint under section 36.
Minor.
Right. And 4A or something like. So there also, in view of section 67, the statement is not to be treated as
My lord.
confession because it is hit by section 25.
Now,
So in view of that, it is further fortified that this observation perhaps is not true.
my lord, that is number one. And second, even if, my lord, if you see, my lord, even Prevention of Money Laundering Act also. They are
Same-
also. the
Same
thing, my lord.
principle,
Simple, my lord, they, what they
but
do.
why he is saying? Because
no,
he has
no,
categorically
no,
said,
No, no, he
the
does.
statements so recorded by the inquiry officer of the RPA cannot be excluded. He
No.
knows about that. The trial court,
My lord, yes.
he knew about that. That is why he made the observation. The statements so recorded by the inquiry officer of the RPF cannot be excluded or discarded from the evidence because the RPF is not deemed police
My
in
lord,
the meaning of section 25.
my lord, that is a, but no, that, but he has not described anything, my lord.
You have to dislodge it.
My,
You have to dislodge it.
my lord, it's fine. Initially, that is why I say regarding this statement which has been recorded.
Okay, a few more are there. Paragraph,
Well,
let us.
The fact of the screw seals by the RPF belong to the railway is undisputed because of PW 8 Uddhav Bora, who examined the rail screw, had duly deposed the rail screw that he examined were exclusively used by the railways and seals material were serviceable condition. Well, that is also important. Why I am initially saying regarding the screw. So it is, I can use, meaning that railway can use, but whether this property belongs to the railway or not, there has to be a certainty. In this case, below, there is nothing sort of that. A track was been found and a person, 13% has been arrested. And he said that he sold one screw to that. He said that this type of screw has been used by the railway. Now, whether the railway screw has been stolen or tape or whatever it may be, below, so that has to be proved by the prosecution, my lord, is the railway agencies. In fact, during the cross-section, defense digs its own grave by asking the rail screw board, the IR Indian Railway mark, to which the PW answered that railway screw had marking of IR to show that those were railway materials. The defense adduced the evidence of DW1, Mukul Das, to show the accused did not deal with any aeroscape business, but the deposition given by the witnesses itself. It's shaky at the time of he cited his ignorance if the accused had any iron business. And at the time stated, the accused had no iron business at all. The witness tried to show the accused was arrested when all of them are gathering, enjoying the warmth of the fire, but faltered to say the exact date of being arrested. The defense wanted to take a opportunity plea of alibi, but failed to prove the same in totality. The deposition of the defense witness failed to evoke the innocence of the accused in the instant case. It is also noticeable aspect that the version of DW1 and the response to the accused during the exemption of 313 of the are totally different, as of the accused stated that he was called from home and arrested in this case. The defense itself failed to link up his own case innocent in the instant offense. The evidence rendered by the prosecution in the case clearly show the accused Deepak Gupta was in unlawful possession of the railway metals, not only a very unlawful possession, or also cast reasonable doubts that the accused has stolen the railway metals. It is a principle endowed in a criminal jurisprudence that once the prosecution prove his case through present evidence and the burden is shifted upon the defense to show its innocence, and there are factors of innocence could not be proved by the defense at the instant offense in the case of accused on the very basis of the discussion of the fact and the law as mentioned above. It is transparent that the prosecution in the state case traveled beyond all reasonable doubts. Accordingly, the doctor is convicted in the same. The privileges enumerated in the section 3 and 4 of the provision of are not considered against accused, as he has committed an offense knowingly. The nature of the case clearly suggests that rail screws are recovered and concealed with other materials in the truck. I have heard Deepak Gupta on the point of censure. He stated he has a burden on the so the case, the jail leniently. The circumstances of the case does not from me to deal with the accused leniently in the any matter considering all aspects before Gupta sentences to undergo civil appeal of 6 months. The period already undergone, the accused shall be set off under section 428 of the Criminal Procedure Code. The same bail is to be handed over to the concerned railway department for its use.
How the appellate court has appreciated the,
My lord, the appellate court, my respectful submission, did not appreciate anything about so far,
what is said about this section 25?
my lord. My lord, can you see, I just paragraph 12 onwards, my lord.
So finding of fact is that you were among the 13 persons who were in the truck.
That was
Finding of fact,
finding of facts.
we cannot disturb
My lord, yes, finding of fact that. Now there are two things, my lord. You lordship.
because trial court and
Well,
appellate court.
No,
Let us
My lord.
confine.
So for the fact,
Finding of fact by the trial court and I think found by the appellate court is that you were among those 13 persons who were inside the truck which contained the alleged railway screws,
my lord,
right?
my lord,
That is the finding.
my lord,
We cannot disturb that finding.
my lord, yes, that is unshaken, but, my lord,
The law points are different.
Ah.
But finding of fact is that you were among the 13 persons who were found inside the truck.
my lord.
You raised plea of alibi on all this
No,
thing
no,
will
I'm
discard.
not a plea of alibi. Now the question before your lordship is this, so far that.
We'll go to the question.
uh,
Finding of fact is that
My lord, finding of fact,
on a particular day at some hours, Nahorkotia police station intercepted.
it was rebuttable, rebut is there. The finding. of
We are in
fact-
revision.
Yes.
We are in revision.
Revision means in the trial, my lord, what has happened? That was rebutted in the trial. So the facts is concerned, my lord, it was rebutted. Just now your lordship has read, so the 313 is concerned, my lord. 313 says I have been picked up from the home, which has been, my lord, corroborated. The defense evidence not by me, a different person. That we are, my lord, having a fire in the front of our house, and he has been picked up from there.
Who you said.
Not me, my lord, defense witness. But here, these are not, my lord,
Defense witness is not inspiring confidence.
no, your lordship has to
To
know
be- to- let us-
whether his test.
So you have many law points to argue. So
Law,
far,
my lord, law
but
point is,
so
law
far
point
if-
is this, law point is this, number one is this, whether this materials belong to railway or not. That has,
those are different. Whether it belongs, because 3 points were framed for determination.
Man.
We are not on that. Finding of fact is concerned, your plea of alibi is discarded.
okay, fine. Well, I
Even
leave it,
DW1 is not inspiring confidence.
my lord,
Finding of fact is to the effect that Nahorkotia police intercepted a truck on a particular day.
my lord,
On having searched the vehicle, they found certain materials primarily belonging to Oil India, and among those materials, certain screws were found,
my lord,
right? And inside the truck, 13 persons were found.
yes, my lord.
And among those 13 persons,
I
you
was-
were one.
I was also, there.
And others were found absconding. So their trial was separated, and you are the only one who faced the trial.
my lord,
I think that is the finding of fact.
my lord,
And one aspect is during your custody in Dibrugarh jail, whether in an inquiry, okay, he is an officer in charge. He can do so. He can. In which case you are arrested? Nahorkotia or
Was arrested in both the cases.
how I can be
Pipe-
arrested in both cases?
All India's pipe, it was off in the freight truck.
what happened to that case?
That case is, I think it was also disposed of,
Huh?
the long pending case.
Can it be, my lord, I have, for the first time, I have heard that I did on the same offense two
No,
two
same-
proceedings.
Shown arrested.
Oh, yeah. Railway case, your case, no.
Ultimately, the theft.
Not only the officer. Okay, so in Tufan Singh, on what principle?
The principle which has been laid down.
We
in
have-
the
we have-
Tufan Singh,
Broadly, I know,
but
but the reasonings given, I have forgotten. Huh?
No, no, no,
No, no,
no, no, no.
Tufan Singh is not on
No,
that.
no, no, no.
Section 67 NDPS Act.
And the piece.
Regarding admission.
No. Admission 67.
67 is not applicable.
No, 67 is to be treated like section 25. I think that is the principle.
Yes, 25, it is a equivalent.
Evidence, evidence act. This is not
That is a-
admissible.
That is a.
And more particularly, if I remember correctly, we have to see. When the inquiry officer is invested with the power, all the powers of an officer in charge of a police station might be the same thing. And every judgment is retrospective.
Yeah.
I don't know the controversy regarding nowadays ground of arrest, but otherwise the law is, everything is retrospective.
That is the one dissent and two has. Agreed. Now,
But
even
that has been
Sina-
followed.
That is followed. Now, where there is saying that NDPS, well, not only NDPS, the others, customs.
That is one aspect that section
Yes.
25 is
Right.
applicable or not. Secondly, Mr.
Because
Biswas,
Well,
in criminal jurisprudence, to hold a person guilty of an offense of theft, it is to be established that the materials were stolen. Now, point for determination. Whether there exists reasonable suspicion of the involvement of the accused persons in stealing the materials from any of the sections of the railways. This is the point of determination by the trial court. So where is the finding?
nothing.
in this case, actually it was detected by the police.
Right.
Then police has informed the railway that these are your property.
Section 9.
That railway RPF people has come to the picture. And registered a case. And that's why RPF went to the police station with the permission to examine the Mr. Gupta who was inside the jail. It's an international thing, how to get PS case. So that is now only controversy that you have raised by people, very that point. Whether there was any missing entry, missing, that is the railway property has been stolen from some place.
Can you connect the accused
Yes.
with the stealing and unlawful?
Can I remember what happened in the railway cases? Whenever they found any railway property with the mark of country, railway property, it has been examined by their expert. And they have.
I accept it is a railway property.
That's why they reject the railway property. But
Okay,
here
railway
also
property.
There is a very good point that whether there was any missing entry or where from it has been. missing.
Because
So,
every railway property is reported.
either from the go down or their store.
To connect. It is stolen. Let us admit. It is unaccounted for. All these clues. But you are the railway protection force. You have to find out. And it is not small. 2,000 plus.
Yes, ma'am.
1 or 2 or 100 screws missing is a different thing. It is a 2,000 plus screws, right? 2,200 something. So it has to be accounted for.
That
There
not
could
raised
be
by-
possibility of shielding.
That aspect is, link is missing.
Because you are shielding somebody.
There are person in the.
2,000
are saying it
screws
was-
stolen from railway godowns.
Of the voters.
And you are going after only one person or 13 persons, labor kind of person. But who had allowed those 2,000 screws to go out of the railway godown? You did not prosecute. Deliberately, perhaps.
No, prosecution was done, but they were too responded.
No.
They are laborers. They are.
They are laborers. No, there is a godown.
Yes, yes.
There from 2,000 plus screws were missing, having railway marks.
There should be.
There be many officials.
Accounts ought to be done, why, how many.
That was not, that was not. So how is the connect? How is the connect?
But the prosecution also, defense. of the-
Railway property is there,
Yes.
but railway property is stolen, whether it is proved.
But defense also did not raise those questions at the time, that it is not.
Let us see the LCR.
Yes, what my learned friend has said, I just, for what, it was not informed by the police, it is informed by the RPM itself. And your lordship see, there is a specific, my lord, a specific question was been asked, whether there is an FIR to that. Your lordship, can you see the 8? What it says, 8 is the expert who, on the prosecution side, railway, has examined me.
No, who said this thing?
PW 8
No,
minute.
that admission of guilt,
Oh, admission of guilt.
period 13.
PW 13 minute.
Let us have.
Sampak Kumar, it is Google. No, Milord. It is.
It is Google. It is
Google and it is Google.
Yes.
And Sampakali,
13 months.
Sampakali is a PW 12
Jailer.
Jailer, state jailer.
We'll look into it. He is Deepak Gupta, right?
Well,
And it was exhibited as statement.
18. 18. Now 18 is not only
18. 19. Oh, you are a temp owner.
Yes,
Huh? You are dam owner,
seated, I'm the dam.
huh? And where is the Naharkotia police station, officers?
No state, nothing. They are not been
no.
examined. They are not examined.
You are not agree.
No, that is a fatal measure.
That FIR was examined, no, exhibited, no.
No, nothing.
Exhibit one is the complaint.
Milo, complaint. Complaint is by the RPF itself.
Exhibit five.
By Jiveswar Mushwahari Milot. Before the Inspector RPF Muriani Milot.
1 minute. Where is that complaint? One. So, Vishwas, can you find out the complaint?
Milot, complaint I have Milot. I have the complaint Milot.
Like, here it will be available.
Oh, yes, sir. Definitely, they'll be available Milot. Complaint is
Exhibit one, exhibit one.
Exhibit one, that is 7/2/2006. Addressed to the Inspector RPF Muriani in NF Railway. By Exhibit one, that is by Jiveswar Mushwahari.
Trace out, trace out.
Ah. This is,
Mr. Bora,
my lord. Where did the,
you have an obstacle to crossover.
my lord,
You have an obstacle to crossover.
which one?
1980 for SSC 600.
1980, my lord.
Having known this judgment, you have not placed, or having not known.
No, I know, I know. It is judgment, I don't know, but so that.
Railway Act, Section 25. Criminal Procedure Code, Section 162, police officer who is test officer of RPF, making inquiry under Section 81 of the Railway Property Unlawful Possession Act 1966, held not a police officer within the meaning of Section 25 of the Evidence Act or Section 162 of the Code. Position of customs or excise officer also not different in this regard. Hence, confessional or incriminating statement recorded by such officer under Section 9 of the 1966 Act in the course of the inquiry cannot be excluded from evidence. Inquiry under Section 81, distinct from material aspects from investigation under Chapter 14 of the Code. We have to examine this judgment along with Tufan.
I think Tufan cases that.
That is, we
that-
have
that-
to,
It has.
we cannot.
My lord, it has been discussed with, I think.
This is why Justice R.S. Sarkaria and O. Chinappa Rendi, two doyens of criminal law.
My lord. So that is why, my lord,
We have to taste it.
right, my lord,
We have
because.
to taste this along with the Tufan system. Because if I remember correctly, all these customs and all, they were treated to be police
Yeah, but-
officer. In
Here
Tufan.
also, in this case.
No, that point is to be cleared.
Definitely.
Otherwise, we cannot go here and there. This judgment is there. Tufan is to be tested along with this.
And this one.
Then only this part will go. If Tufan prevails over this,
Definitely.
right? Then I have read your 161 statement, not 161,
That.
confession statement,
Confess-
right? You were a dump owner, truck was intercepted when you were loading things from your dump to the truck.
Mm.
But unless this statement goes, that is an incriminating evidence.
Definitely. Now, whether it will be hit by
So, if-
25 or not, that has to.
that is what? If that 25 is applicable in your case,
My lord,
then that part will go.
my lord,
And secondly, railway has not proved
That
that,
it is their materials. Whether it is a theft or not, and it has been taken.
otherwise certificate I have seen. It
Certi-
is a railway property.
Maybe railway property means what is it? that has
Railway
been used-
property
That has been used by the railway, this.
are meant for railways, with significant marks. But question is that it has to be missing somewhere,
Definitely.
has
but
to be missing from somewhere.
That is why.
That connect. Otherwise, this admission goes, and only thing that remain. And that is a question which can be examined in criminal review. Let us, you go through then, the other Tufan. We'll get it tomorrow again.
No, no. That's
Since it is
Tufan-
a point of law. And it may have repercussion,
Okay,
right?
this is Tufan Asulu.
We'll hear it tomorrow again. Anything, Mr.
My lord,
Sir?
my lord, this case has been referred to me into Tufan Singh case.
That is why.
1984 SSC 600.
We are not we are fixing it tomorrow. Let
My
me
lord,
also go through
because of
this.
the fact that judgment which your lordship in your hand.
So I remember remotely. That is why I am saying that
That is why.
let us compare Tufan Singh and this one. And we hear it tomorrow.
Because had it not been, my lord, this 1984 SSC case has been not discussed, my lord, that will be a different thing. That was placed on the record, that case. Yes,
Myself have been referring to initially referred
Definitely, my lord,
Tufan Singh. Now I have taken out this one. Oh, we have to compare that issue.
So far this judgment is concerned, Milord, I do not, I honestly, Milord, I do not have any, Milord, idea
Because
about,
otherwise it is clinching
but
against you.
my lord, yes. So by, that is why,
It
while,
is-
while going
It
through
is
the,
the court who is doubting on the basis of Tufan Singh,
Milord,
whether this will
because of
something.
the Tufan, right, Milord, your lordship is absolutely right. Milord, so far the Tufan Singh is concerned, I remember that so far Tufan Singh is concerned, there's a 3 bench judges, 2:1,
Two
Milord.
is to one.
2:1, and so far, while I'm going through, Milord,
And then an issue cropped up for me. I was pondering whether, since it is 2:1, whether that will prevail over a two-bench judgment. Then I got the answer also somewhere, but could not remember.
so.
Yes, Mr. Biswas, let me
Sorry.
hear it. Anything?
I agree with you.
Let us compare this judgment, Balkishan and Tufan. And if it is referred to, and thereafter it is said that section 25 is also applicable in Railway Property Unlawful Possession Act, then this incriminating part of the evidence cannot be admitted. Right? Then that would go. And both trial court and the appellate court had relied substantially on that part of the incriminating evidence. If that goes, whether the remaining evidence will bring the case. Confession, if confession goes, then remaining part of the evidence, whether it can climb to reach the stage of beyond all reasonable doubt. Because standard is all reasonable doubt, beyond. We'll see to that. If not, then revision may succeed. That's all.
And I'll show that, so for the 2000,
Tufan, relevant part
and
where Balkishan has been discussed.
and all the things, Milord, your lordship may also say, because of that is also 2-bench judge, here also.
Will not stay.
2:1.
No, you bring another judgment following Tufan. That's all. That will do.
24.
Tomorrow, we'll hear on that point.
Oh, only point.
We'll examine that too. This judgment with Tufan.
Bas.
And if this judgment is discussed in Tufan, thereafter it says section 25 debars taking such a statement under a statement recorded under 9(3) to read into evidence, then Tufan will prevail. Maybe 2:1, but still it will prevail. And then the other remaining part may not be sufficient. And he has undergone the agony of about 20 years.
20 years.
Is it not?
That's true.
2006.
Para 4. It's been relied on. Para 4.
Para 4 of what?
Tufan Singh.
Tufan.
Para 4.
Madam, you bring a hard copy. I
I'll
find it difficult to read.
Well, yeah, I'll give you the hard copy below. Para 4, this case has been
Tomorrow,
tomorrow at 2 o'clock.
after second half.
2 o'clock, Milord.
Second.
Second.
Okay. Heard Mr. P. Bora, Land Senior Counsel, State by Miss, and Mr. S. C. Biswas, Land Counsel for Respondent Railways. Those raise the case tomorrow as part of case is likely to be taken at 2 p.m.
2 p.m.
2 or any other time, not in the first time.
No, not first.
And madam, you go through the LCR and mark the relevant documents like I have marked here. So that
It'll be easier
less
for-
time is consumed.
Well,
Yes, Mr. Ras.
If you should also, it's also my lord, we don't also put the appear. We have the picture.
Nobody appears. Mr. Bora was there.
But also there.
Huh? None appears, none appears. Huh?
Even the pendency of this.
Now, what is the case about?
The process was issued.
Manager, registered company.
The PF amount that has already been deposited, my lord. For which this, the complete case was filed.
This is, who is this petitioner? Vikram
He
Sethia,
is the manager, my lord, manager.
manager. Then what happened? Appointment order joined. And meanwhile, PF office filed a complaint before the students against Mota managing director. Building them. Process on the same day. Okay, this is regarding someone.
It is someone.
Then what happened? Subsequent development?
During the pendency of this complete case, my lord, they are the, regarding the deposit, they are the PF amount. My lord.
Okay, then what the officer, office of PF office did? Did they withdraw?
No, number, still number.
Why?
The procedure has been under challenge by this, under section 4.
If the money is paid,
Money has been paid.
would the PF officer withdraw the complaint?
Now we are not very serious to pursue with them. No, my lord. Is that-
Okay, if the interim order is vacated, then
My lord.
there is an interim order. I mean, there is an interim order earlier. Interim order would continue. Earlier interim orders were there.
Okay.
Can we record that since they had paid the amount? If the interim order is, if the petition, this petition is disposed of, disposed, you can say so, I'll dismiss it. I'll dismiss it. But if it is closed, then PF office will withdraw because they are have no further grievance.
We are not pursuing them at the moment.
Ah.
But it's still left from like where
Okay.
it is.
Okay. There is no representation on behalf of the petitioner today on call. Full stop. When the case was called, huh? There is no representation on behalf of the petitioner. The case is called today for case on call, huh? When the case was listed earlier on 10/6/2025, none appeared for the petitioner on that occasion also. Post of Mr. N.C. Das Lion Senior Para, Mr. N.C. Das Lion Senior Counsel, assisted by Ms. J. Bush, is present for the respondent number Mr. A. Sharma, then additional public prosecutor for the respondent number 1, B. Sharma. Respondent 1, State of Assam, and Mr. N.C. Das, and Senior Counsel, State by so and so, and Counsel for the respondent number 2 are present. Full stop. On the previous date of listing, that is, comma, on 10/6/2025, comma, the learned counsel for the respondents were present. Full stop. On 10/6/2025, comma, the case was adjourned due to non-appearance for the petition on call. Para. The respondent number 2 is the Assistant PF Commissioner and Inspector, Office O stroke O. The AT, EPF and PF scheme, Jorhat Zone, 80 Road, Toraja, Post Office and District Jorhat. On in the year 2013, the respondent number 2 as the complaint instituted a complaint, registered as CR case number 73/2013, before the Court of Land Chief Judicial Magistrate at Jorhat on 28/2/2013. Page 19, huh? Alleging commission of offences under clause so and so, so and so, so and so. And two accused persons. And two persons who were arraigned as accused. And they were the complaint. Two persons were arraigned as accused. And they were, oh, yeah, yes, 1, 2. Together. Para the learned. Right, the complaint was transferred to the Court of Learned Additional Chief Judicial Magistrate, Jorhat, within bracket, the trial court for disposal. The trial court, upon perusal of the complaint, and taking note of the fact that the complainant is a public servant, within the meaning of section 21 of the IPC, dispense with the initial deposition of the complaint under section 200, Code of Criminal Procedure 1973. As per the proviso of small a of section 200, CIPC. By an order dated 28/2/2013, the trial court took cognizance of the offences is 22 under section so and so, read with 46 of the scheme, and issued process against the two accused persons. Agreed by the order dated 28/2/2013 of the trial court, taking cognizance on the complaint and issuing process, the petitioner projecting himself as the manager of Gobru Purhat Tea Estate, had preferred the instant criminal petition under section 482 CIPC, seeking quashing of the proceedings of complaint case number 73/2013 and the order dated 28/2/2013. Initially, while issuing notice to the respondents. On 26/8/2013, further proceedings of the complaint case here, case number so and so pending before a court of navigation, Chief Judicial Magistrate Jorhat was directed was suspended in the interim till the return of the date. Post of the said interim order was continued subsequently. It was on 23/9/2014, the criminal petition was admitted for hearing. After notices were served on all the respondents and upon appearance of all the respondents. Para. It is seen from the complaint that there was default on the part of Gabru Purbat Tea Estate.
Should be Gabru Purbat.
Purbat. Gabru Purbat. Purbat, of there was default in depositing provident fund contributions to the extent of rupees 48 lakh
48 lakhs.
93,637.32
For the period.
for the period from 18/7/2011 to 22/9/2012. Mr. Das Leonard, Senior Counsel, appearing for the respondent number 2. By placing in office letter bearing number so and so dated 24/9/2024 of the Assam Tea Employees Provident Fund Organization within bracket book formerly known as so and so. Has submitted that a provident fund contributions payable against the for the period from 18/7/2011 to 22/9/2012 in respect of Gabru Purbat Tea Estate has been deposited during the pendency of the instant criminal petition. And as such, the respondent number 2 does not have any complaint as regards the allegation made in the complaint at present. Close. He has fairly submitted that as the area amounts of provident fund contributions amounting to rupees so and so has already been deposited. The complaint petition filed before the Court of Learned steps would be taken for withdrawal of the complaint petition instituted before the Court of so and so. If not already withdrawn, Post. But having regard to the issues involved in this criminal petition, comma, this could, as stated, I know, comma, this court is considered is that no effective purpose is going to be served by keeping this criminal petition pending. So, apart from this interestedness shown by the petition, by their non-appearance on 2 occasions, the subject matter of the criminal petition appears to have become in practice. The criminal petition is therefore disposed of on non-prosecution. It will serve your purpose. A copy of the office letter dated so and so, raised by Mr. Das. Escaped with the case record by marking it as document X. Because it is of 2013. I'll keeping this letter.
Let it be available. Published. What 21?
Your lordship, matter will be fixed, maybe fixed after 2 weeks.
What matter will be fixed?
Because as per my senior instruction, there was a amicable settlement made between the parties.
What is the case about, Mr. Burua? Who is your senior?
M.H. Ahmed,
Huh?
M.H. Ahmed.
Is he available or not?
No, your lordship today is not able.
2014. Amicus is to be changed. Amicus is to be changed.
Already it was said.
Learn it. No. Oh, on the previous date, that amicus is not available. But I have seen her full name. She has been appointed as grade 1. So it has to be changed. No doubt about it. But what is the case about? Let me see 2014, we cannot give an adjournment like that. This is the last one of 2014. Thereafter is 2021 in the cause list. Then 6. Husband and wife. Allegation of kidnapping. There are marital dispute, restitution of conjugal right, guardianship and all. And husband one day took the child. Wife lost the affair saying that my husband kidnapped my daughter. Okay. They are fighting guardianship and all.
The opposite party appeared.
Opposite party is not appearing. Amicus has been appointed, that is why. And yes, what is your instruction? Please tell me. Any document to say that matter has been amicably settled?
There is a verbally, Your Lordship.
Verbally. Verbally will not serve any purpose. This is a 2014 matter, Mr.
Just give it time, my lord.
Huh?
It takes time, my lord. The legal of the customer.
No, what they are, if they are not getting any instruction, amicus is absent. We'll appoint amicus, but we'll close this. There is no nothing. At least in presence of amicus. You suggest who is readily available? Out of the list you suggest. Who can go through the record and quickly understand? Okay, you go through the record petition and apprise the facts to him. Mr.
Rustom Ali on behalf of MSM.
Mr.
Rustom Ali.
Alright. Your name is there? On behalf of Mr.
M.H. Ahmed.
Ahmed. And council of petition is moved. Mr. R.J. Boro. Learned addition of public procedure for the responding one state of Assam. Is also in attendance. Mr. Boro has submitted that the amicus query earlier appointed has since been selected for Assam Judicial Service. And as such, grade one. And as such, common. Another one is to appointed as like a screen to represent the case of harassment. Post of Mr. D.K. Borasai, direct counsel from the panel of Amicus Group, is appointed to in the interest of justice. Come to represent the respondent in this petition. Mr. Borwa, the Judicial Public Prosecutor who has gone through the records of the Come is to apprise Mr. Borasai. Amicus Group. Nothing is there. Once you read, there is nothing. The facts of the case. The name of Mr. School is to be reflected in the progress. So subedition is Mr. Hargivo. Step right. About the listing of the case. Place the case on Friday. No point keeping it 2014. They are blocking new cases. You go through it. This piece of paper is sufficient. We'll exercise 482.
Item number 32.
What is the case about appeal?
So the earlier
Appeal cannot be dismissed by default.
in the case of 302, my lord, but section 304 part 2, my 10 years.
How much is the evidence?
There are 10 cases, my lord.
Paper book may be required.
I have prepared a note, my lord. But my
So
lord,
for the court to dictate,
entire case is based on circumstances and everything.
maybe
As well as the. Appeal.
302, 4 part B, part 2,
The for part 2 convicted.
part 2.
Trial was.
Let the paper book be ready. How many, sir? How many? Where is the judgment? Okay. 10 witnesses. There is no representation on behalf of the appellant today on call. Mr. R.J. Bural and additional public prosecutor. For the respondent number 2, 1, state of Assam. Respondent state of Assam submitted that the appeal is against conviction of the appellant under section 304, part 2, comma, I guess. Post of around perusal of the impugned judgment and order of conviction sentence, it is noticed that there were n number of prosecution witnesses apart from 5 number of exhibits.
And I think some of them.
Post of the court is of a conservative that for an effective hearing of the appeal. Preparation of the paper book is required and necessary. First, office to prepare the paper book. First, raise the case after 4 weeks for a report as regards to the of the Mr.
M. Ahmed.
Present.
Also, he has already served 5 years
Out of
out of 10. So let the paper be complete because some handwritings are not legible.
Let me even for other board.
so that could be a period undergone. Otherwise, if you go on bail, again you have to serve.
What is mine?
Say it already.
Item number 33.
Second copious list of admission. No. Legal counsel has been appointed till date to represent respondent number 2.
He was recovered by CW.
With on 24/4/2025, the registry was directed to inform the standing council, social welfare department, so that the respondent number 2 could be represented in these cases. I don't know why this order is. The name of land is standing council, social welfare department. be reflected in the respondent side. This is the cases on some other note.
Short date because my
Yes,
petition number is 85 years old.
I'm saying,
You totally get you.
I'm fixing a date.
Yes.
Mr. Some you inform standing council. Social well. I don't know for what reason.
Yes.
But since there is an order,
I am moving.
On behalf of Mr. R. Chakraborty, he is out of station due to his father's statement.
statements. Okay, Miss
R. Vasundhara.
R. Basumati, Land Council appearing for Mr. R. Chakraborty, Land Council, but a petition has submitted that Mr. Chakraborty is out of station due to illness of his father,
Parents too.
due to his father's state. Mr.
Opinion. That's number two.
Okay, MP Goswami one, Pino two are present. Please the case after you. 92 is better. 2024. We are fixing case of 2013-14.
Yeah, see,
What agency?
Trial court not pass the effective order due to pendency of this case.
This is criminal petition.
I have the certificate to be out of trial court. They are
On
not passing
Kivara
effective order.
delivery. Yes, Miss. All
Available warranty for the bill. What
he
is-
will order to keep. Already signed, uploaded. Next week. Already signed, uploaded. I cannot call back now. All the orders passed in the first half have been signed. Next week. Make a mention, it is already ordered in the next week. I have signed it, I cannot change it. Long back I have signed.
I was sitting there.
By 120, I have signed all the first half orders.